Hey, good morning, everybody. Welcome to the first live stream for our brand new trial, Courtroom Confidential live trials. I'm so glad to see so many people here. I'll be honest. Good morning, Cheryl. Good morning. Have a blessed day. Cheryl and Hazel and JC Broadway and Afton and Shell and who else is here? I'll be honest with you. P. Lola's mom and Hazel and Simi Sharp. I will be honest with you guys. I thought, you know what? We might be starting this and absolutely zero people watching. So we should be prepared for that. Thank you guys for being here. It's early for me. It might be early wherever you guys are at. Even if you're on the East Coast, I'm still going to say this is just barely getting your morning started type of time. But you can see from the fan, we are live. We are prepared. We are ready to go. We're going to be watching some Karen Reed. We'll talk a little bit about what to expect or what I'm expecting out of this new trial. I know that a lot of people, it's funny, we get a lot of feedback from people saying, love your channel, love what you're trying to do, but I have zero interest in Karen Reed. And I'll tell you from the get-go, I kind of get it. I get the Karen Reed fatigue. I get that a lot of people are like, I've seen this case, I've heard it, I don't want to talk about it anymore. But then there's a lot of folks who are like, I can't get enough of this. This thing is just so intriguing to me, and I'm so invested, and I want to see this through to the very end. And I don't care if it had to bleed over into a sequel, I'm going to watch it again. I personally feel like it's one of those things where I can't take my eyes away, mainly because I know some of the players involved. I mean, I've known Alan for 20-something years. I've known Liza for going close to 10 years now. I mean, it's, these people have been a part of my life, and I think they're great attorneys, and it's just fun to kind of watch them do this. So yeah, that's kind of part of the reason, is almost a voyeuristic thing for me. I'm here for you guys more than Karen Reed. Oh, JC Broadway. I appreciate that. I appreciate everybody showing up this morning. Marie Jubenville, good morning from Birmingham, Alabama. I'm excited about this new channel. We are too. Let's talk a little bit about why we started this new channel. We know that a lot of the community loves to watch live streaming of trials, and we don't do a lot of that on Courtroom Confidential, the main channel, because we like to do kind of commentary. And I still work as an attorney, and it's hard for me to find the opportunity to sit and watch a trial. So sitting there every single day, 8 hours a day, watching a trial is difficult. We have here or there tried to pop in and watched, cross-examination or, maybe the main witness testifier, opening and closing arguments. But we thought, you know what, people want a place where they know, and I see some movement on the camera, where they know they can go and watch the entire trial. And I thought, well, our community of people are so incredible and so kind and supportive, and maybe they want to know of a place that they can go and be guaranteed to watch the trial and not have it, be filled with a bunch of distractions and fluff or something else you're avoiding. I know sometimes when I want to watch a trial, I'll flip through a few different channels because it's like, maybe somebody's talking too much, maybe somebody's talking too little, maybe I'm looking for something else. And I thought, you know what, let's just give people a place where they know they can go and watch it. So I'm going to try to be here as much as possible and watching alongside with you, and either on screen talking about it or in the chat talking about it. But sometimes it's just here for everybody else to just have a place to meet up and watch the trial as we stream it live. And we're going to be doing that without ad breaks, and we're going to be doing that with the Courtroom Confidential community and whoever else decides to join us. So thank you guys again for being a part of this thing. I will just kind of talk a little bit about this new trial and I think what to expect. And then if things get started in court, I'm going to shut up and maybe I'll interject here or there. But I will say the first thing I would caution everyone is that this is a brand new trial. And I know that's kind of silly to say, but what I mean by that is, don't have the idea in your head that any ground lost or gained in the first trial is going to matter at all in this second trial. It is starting all over. Now, we know a lot of what the witnesses are going to say, and we know a lot about what they can't say. In other words, you cannot have a witness go up and completely change their testimony. If they do, they'll get ripped to shreds on cross-examination. So we're going to expect to hear much of the same things, but so much of a trial is about not just what the person said, but how they said it and how they performed and how they stood up under cross-examination. And a lot of these folks were ripped apart during cross-examination. I thought the defense, I think, if anything, no matter what side you come out on this whole thing, you've got to applaud the defense attorneys for putting up an incredible trial. I really think that they did. Now, will they be able to capture that lightning in a bottle again? I don't know. Will they be able to recreate those gotcha moments that they had the first time around? Probably not. And that's why they usually say that retrials favor the prosecution, because so much of the defense, do they get to mention the first trial? They're not going to talk about it, but it's going to become a thing. In other words, they're not going to say in opening statements, this is the retrial of Karen Read. I'll fall out of my chair if that happens. Usually this is something that is kept out of the courtroom, but they will talk a lot about, well, didn't you previously testify? And that I've done retrials, and it somehow comes up, and jurors somehow put it together that this is not the first trial. And that usually is not a problem. I mean, I think jurors are savvy enough to understand that retrials happen for any number of reasons. And just because we're sitting here again doesn't mean that the person is any more guilty or not guilty just because they're sitting here again. And I saw that the fan, who's going to become our good friend over the next few weeks, froze on me, but the channel hasn't frozen because I see the feed is still going. So I don't know if they're having technical difficulties over there. But great question. But I think that I think that is sound kind of expectations, that usually the second time around it favors the prosecution, because so much of a defense case is about catching witnesses off guard. And when you've already caught them off guard, how do you catch them off guard again? This case, though, has one interesting wrinkle in it, in that you've got a major development with one of the major witnesses of the Commonwealth that had taken place in the meantime, and that is with Michael Proctor, obviously. So he got absolutely ripped to shreds the first time around. We know that since then he's been investigated by his own department. Since then he's been fired by his own department, and he's going to be a part of this case again. He's the lead investigating officer. There's no way that this case can take place without him, and it's going to be interesting to see how the Commonwealth handles that. How does Hank Brennan handle that? If I were the prosecutor, I feel like I would want to get out ahead of it and steal as much of that thunder away from the defense as possible. In other words, I'd call him to the stand myself and spend the first half hour or more talking about what a complete jerk he is and all of the horrible things he did. That is not me pressing numbers. And all of the reasons that he got fired, and all of that, get it all out up in front, and then just kind of slowly try to right that ship and say, okay, but let's talk about what you did and what you actually collected and what can be corroborated. Now, can he do that? Can Hank Brennan pull that off? That's going to be a remarkable thing. But the other strategy is let the defense do it. And when the defense calls him, it's their witness, and you can treat it however you like and figure that you'll just explain to people that is a witness that you did not need, and that's why you didn't call them. I think that's a strategic mistake, but we'll see how this all plays out. But that's one reason why I feel that this is not a traditional retrial, in the sense that I would hedge my bets towards the prosecution. This is one of those cases where there's a big kind of unknown factor with the Commonwealth's case in how will they handle this. So yeah, treat this like a brand new trial. Treat this like this is the first time going in. All that evidence has to be proven again. Everything the Commonwealth proved the first time around has to be proven again. All of the doubt that the defense created the first time around, all of that kind of momentum that they had going that first time around, they have to recreate again. And I'll tell you this, psychologically, from a attorney's perspective, retrials are, God, they're awful. I've heard it explained as though it's like putting on a wet swimsuit. It's just when you're already cold. It's just that awful feeling of, this is uncomfortable. I hate doing this. I don't want to do this. I've done a couple of retrials in my life, and excuse me because I need to have some coffee because it is early over here on the West Coast. I've done a retrial. I did one very big retrial that was televised, and it nearly broke me. I mean, you put so much into that first trial around, and then to be told, I think that hung, I think it was 10-2 for guilt, and it just devastating the way you feel about it. And you get over it, and you start to put some perspective on it, and you realize it's not the end of the world. But God, gearing up to go through that again and having to convince some of those witnesses who didn't want to testify the first time around that you need them to come back into court again, it's just awful stuff. Alan famously went through a horrible retrial. I was his law clerk. Alan tried Phil Spector twice. The first time around, it was 10-2 for guilt, and it was declared a hung jury, and that was televised on court TV every single day. Huge high-profile case in Los Angeles. He's the lead prosecutor, and it hangs 10-2, and he was just wiped out, and we all felt bad for him. I mean, when he took a few weeks off from work, and when he came back, it was all like we saw a ghost walking around the hallways, because we all kind of like didn't want to get in his way, because it was just like, this poor guy, what he had done through. But he saddled back up, dusted himself off, put on a retrial, put on a hell of a retrial. That was when I was his law clerk, and won and got a conviction out of it. Oh yeah, they're going through Spectre number 1. It's too bad that Spectre number 2 was not televised. But yeah, at least you're getting an idea of what an intense trial. And that trial in many ways is kind of similar to this case. And here's why I'm saying that. That case was so huge, but over an incident this small. Like, Phil Spector was not accused of going on a killing rampage that lasted over several days with several different victims. It was a shooting of Lana Clarkson, one woman, on one evening. And the amount of witnesses to what should have been a very straightforward case. Had that not involved Phil Spector, and that was just any other person charged with that crime, that case would have lasted maybe a week, including jury selection. But it lasted six to 8 weeks or something. Maybe you can tell me, how many days are you into it already now, Afton? Because of something that became so incredibly involved. And I feel like this case is kind of the same with Karen Read. You've got a fairly straightforward case. Commonwealth says she ran him over. She's saying, no, I didn't. And now we're into what? Trial number 2, and it's going to be 6 weeks, and how many different witnesses being called? I never forget Fiddler reprimanding Cutler. That was so awesome. I remember that happening live. Cutler was quite a character. Fiddler being one of the best judges I've ever been in front of, too. He's fantastic. I've had trials in front of him myself, aside from that one. Anyhow, that's just my point of, like, it's going to be so difficult to gear up and go through this just from an emotional perspective for these attorneys. Oh, one more thing, though, the defense to think about. Here's like an instance, a great example of what I mean about those magical moments that can't get recreated. Do you remember the flipped video? Again, putting aside, let's all agree for at least this morning to put aside the preconceived notions of what we have about this case, and just to try our best to go into this completely with open eyes and open ideas. If you remember from the first trial, that flipped video was quite a moment. I mean, it was something that is, yeah, do we remember it? It's hard to forget, because you just don't ever see that happen. That's like out of a poorly written TV drama, right? That, oh, the video would be flipped and the prosecution wouldn't notice that. wouldn't notice they had an inverted video and just be going and talking about the whole thing and wait until the defense gets up there and just reveals that to the world in real time. Just incredibly dramatic stuff. Not going to happen. Not going to happen this time. Hank Brennan's not going to put up an inverted video and go, oh, wait a minute. So those kind of magical moments for the defense are going to be hard to recreate. For the prosecution, they've obviously, hopefully been able to prepare their witnesses again. I imagine all these people are so sick of it, they want nothing to do with it, the way that their lives have been turned upside down. But for the prosecution, there's also the difficulty of knowing that your case is not necessarily going to improve. In other words, your main witnesses, the medical examiner, is not going to all of a sudden change her opinion. You still have to deal with accident reconstruction issues of how do you prove all of this. There's still going to be dog bite questions and experts presented by the defense. So it's not as if this case became easier for the prosecution. It's not as if they've gained evidence in the meantime. It's just that now they don't have the disadvantage of the defense being able to have these gotcha moments. So that's just kind of my quick thoughts on this. Some other things to think about, some factors are that we have a new prosecutor. I am not going to be cheap and pull shots on Hank Brennan, and you'll forgive me, I'm wearing glasses this morning because I woke up and my eyes were a little bit red, only because I probably stayed up too late. But the Hank Brennan, Adam Lally, this is what I was going to say. I'm not going to throw poor Adam Lally under the bus. Adam Lally is, by the way, oh, thank you, JC Broadway. Adam Lally, by the way, is 90% of prosecutors you will ever come across. Not the ones you see on TV and you watch. Thank you, Robin Hood. I appreciate you. But the prosecutors, if you were to go into any random courtroom and just watch a criminal case going on, it's full of Adam Lallies. Just these straightforward guys. Been doing it for years, career prosecutors. They're not trying to light the world on fire. They are just, here's the facts. And isn't it true? Such and such and such and such. And if we get started, I'm gonna shut. You can watch as much of this. And I think there's gonna have a little bit of maybe some argument this morning too.
This court is in session.
Let's jump in and I'll
2282 CR 117, the Commonwealth versus Karen Reed.
So, good morning. I see all counsel are present. I see all counsel are present. Nobody said anything to Mr. Clerk about needing to see me, but I received 4 motions over this weekend that I assume we need to at least talk about briefly. Commonwealth's motion regarding defense opening statement. I think the first 2 motions we can do quickly. I'm not issuing an order. Mr. Brennan, the defense knows third-party culprit will not be in the opening. If you think that their opening goes beyond it, you can object. Defendant's opposition to the Commonwealth's request for use of independent readers, because there's an objection, the defendant's motion's allowed. So you will not have an independent reader. Is it fair to say that the 3rd and 4th motions, Commonwealth motion to enforce compliance with court's April 16th ACCA discovery order and the Commonwealth's motion to preclude new expert testimony or alternatively to continue the trial date, that those motions will take a little bit of time, Mr. Brennan?
I don't think I'll be long in my argument.
I think that I need more information on one of them. And I think we'll do that at the end of the trial. I mean, at the end of today, we'll hear both these motions. Mr. Jackson, I did see that a list of text messages, 100 or so, is in your response to my order on Friday. Did you provide the text messages themselves? All right. In light of that and the fact that we don't have time, the juror's been waiting for some as many as 3 weeks now, I'm going to prohibit you from mentioning ARCA in your opening statement. And then we'll deal with this later today. I ordered those text messages and they weren't delivered. So we're going to be bringing the jury in. I'll be in recess for 5 minutes.
Heard on that, I think the court respectfully may be factually incorrect on a key assumption of what Your Honor is ruling.
5 minutes, Mr. Alessi.
Mr. Jackson's going to give you the facts. I would like to hear the law back.
That's more than 5 minutes. I'll see you at sidebar. Come up here.
Already, right? There's no way this could have started smoothly. I mean, she was breezing through that so quickly. I mean, obviously, the big thing of what she just said was that she's not going to allow the defense to mention ARCA in their opening statements, and you could see the reactions out of the defense team that was not something that they were pleased with, and she's blaming that on some sort of late disclosure of something. I don't know what, but already sidebar number one. So if you're playing bingo, you can check that card. But she wants to get these opening statements started. So I got to imagine. I mean, the ARCA was another thing I wanted to talk about this morning. You got to imagine that ARCA was going to play a major role in the prosecution opening statement. Alan is giving opening statements, which is a switch because last time Yannetti did it. I don't know what that means entirely as far as strategy. Usually when you have a defense team, the more senior, more lead attorney will be the one who does the closing. And if that's true, then you'll have another attorney do the opening because you only get one shot, right? Once at opening, once at closing. You don't get two shots at closing like you do in most cases, except in this jurisdiction. And maybe they just either they've decided that Alan's going to do both, or they just felt that somehow, because I can't imagine this was like some sort of decision that Alan's no longer the lead attorney. He's the lead attorney in this whole thing. And maybe just they felt that, you know what, the last time they didn't set the table enough at the beginning. And also, I thought Yannetti did a fantastic job the first time around. I thought that was a brilliant opening statement. So I'm not quite sure. I'm not quite sure why the switch and what big of a difference that will make. But I will tell you this. He's prepared, and he's been prepared for weeks, and he probably has that thing nearly memorized. And the fact that she's now telling him that maybe a major part of that, hey, Britt Back says, what is ARCA? That maybe a major part of that will not be discussed is going to be incredible. So what the judge just said is that the accident reconstruction experts that played a huge role the first time around for the defense, the ARCA experts, as they've been referred to now, what was at that time at least independently hired experts on the part of the feds, the U.S. Attorney's Office that actually employed them in their own independent investigation, hired ARCA. ARCA came to some conclusions that were favorable to the defense. So the defense called them the first trial, which was fantastic for the defense because you never, as a defense, get some independent witness that is favorable to you. Usually you are hiring all of your own experts, and that's a big challenge, is to explain how can these people be believed? How are they giving an independent assessment of their case if they're being paid? And in fact, aren't they just saying exactly what you want them to say because they're being paid? And now the defense, miracle of miracles, had this opportunity to say, no, they're not being paid. They're independently hired. Well, this time around, not so much. They have had to retain them. They are being paid. They're not going to have that same opportunity, but they are still a major part of the defense's case. And I think the defense could still find a clever way of saying, when you arrived at these conclusions, you weren't under the employ of the defense, and your conclusions haven't changed since the time that you were employed by independent third party, correct? And there would be a way of saying, hey, these are independent conclusions, not influenced by whatever pay you're receiving from the defense. And now she's saying, I'm not going to let you get into ARCA and opening statements. This sidebar, I think, is taking a little bit longer than 5 minutes. Why couldn't they say ARCA were hired by the feds the last time? Because the court and Commonwealth didn't want there to be conclusions drawn or assumptions made by the jury that would have been inappropriate based upon that limited amount of evidence. I'm not sure if they're bringing in the jury. This is what they usually do. Do I know if Alan prefers to do openings or closings? Alan, it's hard to stop Alan from doing all of it, to be quite honest with you. If you got to kind of fight to take any of that case away from him, because he just loves to dive in. So I'm surprised the way this worked out, but I don't think it would be fair to make any great assumptions from the fact that he's now doing the opening. But kind of getting back to ARCA and why they weren't allowed to mention it is that they didn't want the jurors to hear this limited evidence of they were hired by the U.S. Attorney's Office, the federal government, and not understand why that was done. And getting to the place of helping them understand why it was done would have just been such a side venture that they didn't want to get into it. So they just decided to say independently hired. And I think that was the proper way of handling it. So, but this time around, not really, because they are formally retained by the defense now. So that will be handled with the same kind of cross-examination by the Commonwealth. Aren't you in fact being paid? Blah, 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 blah. But at least for the defense's benefit, they can say, yeah, but when you arrived at these conclusions, when you did this testing, when you came out with this report, you weren't paid by the defense, correct? You were paid by, and they might even say it the same way, an independent third party not involved in these proceedings, correct? Correct. So they might be able to rescue some of that. But that was a big thing that Alan pounded. I mean, if you remember during his direct examination of the ARCA experts in the first trial, he spent a lot of time going, you never met with me. You never talked to Liza Little. You never talked to David Yanevity. You were independent. And he drove those same points home during closing arguments as well. So we'll see. I mean, I think it's a cheap shot. I know it's a lot of people's favorite pastime to rip apart poor Beverly Cannoni. I'm not jumping on that bandwagon. And there's a couple of reasons why. One, yeah, I think sometimes she leans Commonwealth. Sometimes she's made some decisions I felt have been helpful to the defense. To me, I'm just, I do feel everybody is genuinely trying to do the best job that they can. Okay. And I give people that benefit of the doubt. But I have also been doing this for 20 something years. And I will tell you, if you had to have me place Beverly Cannoni in the overall lineup of judges I've been in front of and how bad and how good, she's not going to even make the bottom half of that. Okay. Like, there are so many judges out there that are awful, and I would not put her in the category of awful, but I completely understand and I sympathize with Robin Hood says, leans, you were very nice, Josh. I get it. I get everybody watching and saying that she's just in the bag of the Commonwealth. And I think she's done a lot of things that make it appear that way. But I will tell you too, that's just kind of par for the course. Most judges are in the pocket of the prosecutor. It doesn't mean they are biased, but they get defendant after defendant after defendant in front of them, who the vast majority of which there's incredible amount of evidence against them, and they begin to kind of, yes, Robin Hood, lean in a certain direction. But again, I don't want to turn this into the throw poor Canoni under the bus show either, but I will say, in an attempt to be completely objective about all of this, pulling the rug out from underneath the defense within minutes of them beginning their opening statements and saying you can't mention something that you know to be a major part of their case, to me is baffling. And if I were the defense, my head would be absolutely spinning. And I imagine there's a lot of steam coming out of the ears of Alan Jackson and Alessi in this sidebar, which is, by the way, going much longer than 5 minutes. All right, what else? Oh, how important are opening statements? That's a great thing to think about too. Because in a trial like this, by the time you get to closing, you are so far away from opening that I bet you if you even asked the jurors to tell me what was said during opening statements, many of them would have a hard time. Here's why I think opening statements, though, are important. And I think too many attorneys treat them as the roadmap of the case. And I am just here to present to you what to expect out of this trial. And part of that is to do a roadmap, because when your trial is played out, you are not going to be able to perfectly reconstruct this in a narrative, in a story. You're not going to be able to perfectly give them everything in chronological order. You might be calling witnesses out of order. You're going to do your best to call them in order, but it's hard to do that just given schedules and everything else. So a lot of times you want people to understand the roadmap. Here's what we expect to prove to you and why we want you paying attention to certain witnesses, because this is what we want to prove. Hazel says, maybe this is a dumb question. Why would the judge rule that ARCA not be mentioned? That's not very fair in my book. That's an important part of the defense. Sorry for the silly question. Not a silly question at all. And I'll be honest, I'm not quite sure. She said something about disclosure of text messages being made late and over the weekend, and so therefore she's not allowing it. So I don't know. I think she came out, she seemed a little hot, Hazel, and she just kind of it was almost as if she's just experiencing some sort of decision fatigue, and was like, I've received motions over the weekend. We got a jury waiting. We're going to handle all of this later. And so therefore, to avoid making these rulings before we do opening statements, I'm just going to say you can't get into certain things that are in contention. And I guess this ARCA issue is one of them. I'll be honest with you. I didn't quite connect the dots of what she was saying as to why it was happening. Good morning. Ready to watch day one with Cece on your birthday. Happy birthday, Terry L. I can't believe you're joining us on your birthday. Well, I hope this starts your birthday off well. Thank you so much for being here. Always appreciate seeing you. What a treat. I love that. So opening statements, though, why are they important? Yes, they're a roadmap. Yes, they give people an understanding of the story. It's like a preview at the movie, so you understand what the story is about, so you're not completely lost as the case begins. You're not trying to piece together what this whole story of what took place. You kind of get it. But I think far more important, it's about establishing the theme of your case. And that's why I felt like the defense did such a remarkable job the first time around. The opening words out of David Yannetti's mouth were Karen Reed was framed. And that set the entire theme. He could have sat down. He could have said, Karen Reed was framed. And we're going to show you how. Just stay tuned, and sat back down, because he accomplished everything he wanted to accomplish out of that opening statement with those opening words. That's why it's important. I think for the prosecution, same thing. If you're just telling them what you're going to prove to them and you're not cleverly weaving in the theme of your case, you're wasting an opportunity. And yes, it's not the place for argument. It's opening statements, not opening arguments. And many judges will be sticklers about that and not allow you to really argue much at all. But there's a clever way to do it. And obviously, Canoni is not so much of a stickler if she's allowing the defense to get up and say she was framed. So I think that's why these are important. Yes, much of them will be forgotten, but if you don't already signal to the jury the lens in which you want them to view this evidence, it's not just here's where I'm going with the evidence, it's also here's how I'd like you to view the evidence. If you're not doing that from the beginning, that's where you're wasting your time, because they will forget the words, but they won't forget the themes. I guarantee you those jurors may not have been able to recreate what David Giannetti said in the beginning, but they knew it was something about Karen Reed being framed. All right, what else? This sidebar is interesting. This is killing me. This is the kind of stuff that just wrecks your nerves as an attorney when you feel like you're all ready to go and then it just a complete speed bump gets thrown in your path. Oh, this it's going to be interesting to see if the defense, in my view, changes their tactics at all. So this is an interesting case in that it's a retrial, but with some added evidence that they didn't know the first time around, or not evidence, but added information. In other words, you had a mistrial, you had a hung jury. There's some conclusions that both sides can draw from that about the strength of their case. But then we learn that the jury had actually acquitted Karen Reed of the more serious charge of second-degree murder in this. Now, that is some very valuable information that they didn't have the first time around. And what do they do with that information? Well, if you're the Commonwealth, that's not making you feel great. That to me should have made them reassess whether or not to even bring those charges. I feel if the Commonwealth wanted to pursue this case, I think they should have pursued it without that murder charge. Honestly, I think this was overcharged to begin with, and I think if they wanted to pursue it, they should have pursued it with the vehicular manslaughter while intoxicated charge, if that's what they felt that they had here. But they put on a case, they put on all their evidence, and they already had one jury tell them, we don't think you met that. And only by a weird amount of circumstances coming together were they able to not get an acquittal out of that and still learn that that's how the jury leaned. The defense can take that information and say, okay, well, we already know that these jurors are not buying the murder charge. Great. Something we did worked. But then they know that they hung on the other charge. So at least some of those jurors, and I imagine they've spoken to them since then, some of those jurors did not buy the cover-up. They just didn't believe she did it on purpose. I don't know, Tiffany. I don't know if you can look that up and find that out. I am imagining the same amount as we had the last time around, which was, a few dozen. So the defense could say, okay, they don't believe, at least if this first round of jurors can be a test jury for us, they don't believe Karen Reed did this on purpose. At the very best, some of them only believe it may have been an accident. That's some information we can use. But some of them did not believe that she was framed and that she was set up and that there was a cover-up here. Now, as the defense, you do have the great advantage of being able to completely pivot. If they want to come into this trial and completely pivot and say, Karen Reed was there. Karen Reed doesn't know after what happened after John got out of the car. And the prosecution has not proved to you she intended to do any of this at all. And abandon the whole cover up, dog bite, all of that. They can do that because they are not being held to a standard of proving one GD thing in all of this. That is on the prosecution. All they have to do is call into question the prosecution's case. More than 150 on the witness list. I have no idea how many will testify. There's no way 150 people are going to testify in this case, but that is interesting. Thank you for that, Afton. I guess the big question is how many testified the first time around will probably give us an idea. So there is a world where the defense could pivot on this whole thing. Now, it doesn't look, all signs point to the idea that they're not going to do that. But I was thinking a lot about this. And if I were Alan, what would I be doing different the second time around? How would I try to take that information I learned about what the first jury thought about this and use that to my advantage? And something I was thinking about, and Alan taught me this, every case needs a bad guy. And the prosecution, if you're the defense attorney, the prosecution wants to make your client the bad guy. Well, as the defense attorney, one of your main jobs has to be making something or someone else the bad guy if it's not your client. If your client's not the bad guy, then who is? In this case, the first time around, they tried to make the Alberts and anybody in that house
You are muted.
the bad guy. This time
You are unmuted.
and I'm sorry if this gets muffled when the audio starts up again. In this time around, I think a better strategy, and they did this to some extent, but I would, to use that term again, lean into the police being the bad guy. And that doesn't necessarily mean that the police are framing her or that the police are responsible for John O'Keefe's death.
Hear ye, hear ye, hear ye. All persons having anything to do before the Honorable Beverly Cannoni, the Justice of the Superior Court, now holding in Dedham, within and for the County of Norfolk. Draw near, give your attendance, and you shall be heard. God save the Commonwealth of Massachusetts. This court is in session. Please be seated.
2282CR117, the Commonwealth versus Karen Reed. Can I have counsel identify themselves for the record?
Morning, Your Honor. Adam Lally for the Commonwealth.
Morning, Mr. Lally.
Good morning, Your Honor. Hank Brennan for the Commonwealth.
Morning, Mr. Brennan.
Morning, Your Honor. Alan Jackson on behalf of Ms. Reed.
Good morning, Mr. Jackson.
Good morning, Your Honor. Elizabeth Little, also on behalf of Ms. Reed.
Good morning, Ms. Little.
Good morning, Your Honor. Robert Leslie on behalf of Ms. Reed.
Good morning, Mr. Alessi.
Good morning, Your Honor. David Yannetti for Karen Reed.
Good morning, Mr. Yannetti. Good morning, Ms. Reed. Good morning, jurors. So I have 3 questions I have to ask you because I haven't seen many of you for a long time, and we do appreciate that you are all here, ready, willing, and able to get started early. We sometimes have to deal with a few things before bringing you in, but we do appreciate your patience. So those questions are, were you all able to follow the instructions and refrain from discussing this case with anyone since we last saw you? Everyone said yes or nodded affirmatively. Were you also able to refrain from doing any independent research or investigation into this case?
Yes.
Everyone said yes or nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we last met? Everyone said no or shook their heads. Thank you very much.
Jurors, can I have each of you stand and raise your right hands, please? Do each of you solemnly swear you shall well and truly try the issue between the Commonwealth and the defendant according to your evidence and according to the law, so help you God?
Yes.
Thank you. You can have a seat. Jurors, hearken to these indictments. Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did assault and beat John O'Keefe with intent to murder such person, and by such assault and battery did kill and murder the said John O'Keefe, and is guilty of murder in the 2nd degree and not in the 1st degree in violation of Massachusetts General Law, Chapter 265, Section 1. 002, Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022 at Canton in the County of Norfolk, did operate a motor vehicle upon a way as defined in General Law, Chapter 90, Section 1, or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, with a percentage by weight of alcohol in their blood of 8/100ths or greater, or while under the influence of intoxicating liquor, and did so operate said motor vehicle so the lives and safety of the public might be endangered. and by such wanton and reckless conduct so described, you caused the death of another person, to wit, John O'Keefe, in violation of General Law, Chapter 265, Section 13 and a half. 003, Karen Reed of Mansfield in the County of Bristol, on or about January 29, 2022, at Canton in the County of Norfolk, did operate a motor vehicle upon a way or in a place to which the public has a right of access, or upon a way or in a place to which members of the public have access as invitees or licensees, and without stopping and making known her name, residence, and registration number of her motor vehicle, to go away to avoid prosecution or evade apprehension after knowingly colliding with or otherwise causing injury to John O'Keefe, such injuries having resulted in the death of said person in violation of General Law, Chapter 90, Section 24, Subsection 2, Subsection A and a half, Subsection 2. To these indictments, the defendant has pled that she is not guilty, and for trial has put herself upon the country which country you are, and you are sworn to try the issue. If she is guilty, you are to say so. If she is not guilty, you say so and no more. Jurors hearken the evidence.
All right, thank you. All right, members of the jury, I'm about to make some preliminary remarks to you to acquaint you with some of the legal principles, procedure, and terminology that you may inquire during the course of this trial. These comments are not intended to be a substitute for the more detailed instructions on the law that I'll give you at the conclusion of the case. So you'll remember that this is a trial of a criminal case. Ms. Reed is charged with second-degree murder. She's also charged with manslaughter while operating under the influence and leaving the scene after causing personal injury or death, the indictments that Mr. McDermott just read to you. I'll describe the law in detail at the end of the case and the elements of these charges, but briefly, murder is the unlawful killing of a human being. In order to prove Ms. Reed guilty of second-degree murder, the Commonwealth must prove beyond a reasonable doubt that she committed an unlawful killing and that it was done with malice. In comparison, manslaughter while operating under the influence is an unintentional, unlawful killing caused by wanton or reckless conduct while under the influence of intoxicating liquor. And leaving the scene of an accident after causing personal injury or death requires the Commonwealth to prove that Ms. Reed knowingly collided with John O'Keefe, that she caused him injury or death, and then she fled the scene. These terms and the elements of the crimes will be explained to you in detail at the end of the case before you begin your deliberations. Now, please remember that Ms. Reed starts this trial presumed to be innocent. The fact that she was arrested or that she was indicted is not proof of anything. An indictment is just a piece of paper. It just makes an accusation. It is merely a formal manner of accusing a person of a crime and bringing that person to trial in the Superior Court. But it is only the jury, in other words, you folks, who can decide whether the prosecution has proved its case beyond a reasonable doubt. If the Commonwealth does not do that, then the presumption of innocence alone requires you to find the defendant not guilty. The law never requires a defendant to prove her innocence, to produce any evidence whatsoever, or to do anything other than attend the trial. This presumption of innocence remains with the defendant until you, the jury, make your determination after listening and considering all the evidence. Now, what is proof beyond a reasonable doubt? The term is often used and probably pretty well understood, though it is not easily defined. Proof beyond a reasonable doubt does not mean proof beyond all possible doubt, for everything in the lives of human beings is open to some possible or imaginary doubt. A charge is proved beyond a reasonable doubt if, after you have compared and considered all the evidence, you have in your minds an abiding conviction to a moral certainty that the charge is true. When we refer to moral certainty, we mean the highest degree of certainty possible in matters relating to human affairs, based solely on the evidence that has been put before you in this case. I have told you that every person is presumed to be innocent until he or she is proved guilty, and that the burden of proof is on the prosecutor. If you evaluate all the evidence and you still have a reasonable doubt remaining, the defendant is entitled to the benefit of that doubt and must be acquitted. It is not enough for the Commonwealth to establish a probability, even a strong probability, that the defendant is more likely to be guilty than not guilty. That is not enough. Instead, The evidence must convince you of the defendant's guilt to a reasonable and moral certainty, a certainty that convinces your understanding and satisfies your reason and judgment as jurors who are sworn to act conscientiously on the evidence. This is what we mean by proof beyond a reasonable doubt. Now, our system of justice depends on judges like me and jurors like you being able and willing to make careful and fair decisions. All people deserve fair and equal treatment in our system of justice, regardless of their race, national origin, religion, age, ability, gender, sexual orientation, education, income level, or any other personal characteristic. You have agreed to be fair, and I am sure that you want to be fair, but that is not always easy. One difficulty comes from our own built-in expectations and assumptions. They exist even if we're not aware of them and even if we believe we do not have them. Some of you may have heard this called implicit bias, and that's what I'm talking about. Of course, we judges have the same problem as everyone else, so let me share a few strategies that we have found useful. First, slow down. Do not rush to a decision. Hasty decisions are more likely to reflect stereotypes or hidden biases. Second, keep an open mind. Avoid drawing conclusions until the end of the case when you and your fellow jurors deliberate. Remember that when you deliberate, you will have all the evidence and all the time you need to make a careful decision. So there truly is no need to stop making up your mind before then. Third, you should listen closely to all the witnesses. That is the best way to ensure that you decide this case based on the evidence and the law instead of upon unsupported assumptions. Fourth, as you listen to the testimony about the people involved in this case, please consider them as individuals rather than as members of a particular group. And finally, I might ask myself, would I view the evidence differently if the people were from different groups, such as different racial, ethnic, or gender identity groups? At the end of the case, I will remind you of these strategies and ask you to focus on the evidence instead of any unsupported assumptions you may have. All we ask is that you, individually and as a group, do your best to resolve this case based upon the evidence and the law, without sympathy, bias, or prejudice, to the best of your ability as human beings. Now, when I finish these initial instructions, the Commonwealth, Mr. Brennan, will make his opening statement, then Ms. Reed's lawyer, Mr. Jackson, can choose to make an opening statement or not, because again, remember, the defendant has no burden of proof and doesn't have to prove anything. Her lawyer does not need to make an opening statement. An opening statement is a summary of what the lawyer expects the evidence at trial will be. It is intended simply to introduce the main issues in this case to you. Next, the prosecution will introduce evidence in support of the charges in the indictments. After that, the defendant may present evidence on her behalf if she wishes to do so, but she is not obliged to do so. Remember, the burden of proof is always on the Commonwealth to prove that the defendant is guilty. The law does not require any defendant to prove her innocence or to produce any evidence at all. After all the evidence, each side will have an opportunity to offer you closing arguments about what conclusions you might draw from the evidence. Like the opening statements, the closing arguments are not evidence. They're merely intended to help you understand the respective contentions of the parties. Finally, after all the evidence and the lawyer's arguments, I will instruct you in detail on the principles of law which you are to apply in your deliberations when you retire to consider your verdict. Your verdict must be unanimous. Let me speak briefly about our respective roles in this case. As the judge, my responsibility is to see that this case is tried orderly, fairly, and efficiently. It's also my instruction to decide any questions of law that come up during the trial and to instruct you about the law that applies to this case. It is your duty to accept the law as I stated to you, whether you agree with it or not. Your function, you folks are the most important people in the courtroom. Your function is to determine the facts. You are the sole and exclusive judges of the facts. You alone determine what evidence to believe, how important any evidence is that you do believe, and what conclusions all the believable evidence leads you to. You will have to consider and weigh the testimony of all the witnesses who will appear before you, and you alone will determine whether to believe any witness and the extent to which you believe any witness. You can believe all of what a witness says, some of it, or none of it. It's entirely up to you. It is part of your responsibility to resolve any conflicts in testimony that may arise during the course of the trial and to determine where the truth lies. Ultimately, you must determine whether or not the Commonwealth has proved the charges beyond a reasonable doubt. The lawyers have their own important role in this trial. They are, of course, advocates. Their job is to bring to your attention the evidence and arguments that best support their position. They may also object to evidence offered by the other side that may not be admissible under our rules of evidence. Similarly, we may engage in sidebar conferences out of your hearing. These sidebar conferences are not intended to keep secrets from you, but to allow the lawyers a little more time to argue their points so that I may rule on what you may consider as evidence. If I agree with an objection to a question, the term I will use is sustained. You are to disregard that question, and you're not to speculate as to what the answer might have been. In the same way, you're to disregard any evidence that I tell you is stricken from the record. If I reject or overrule an objection, I'll permit the witness to answer. This happens a lot. You'll find this during the course of the trial. If I let the witness answer the question, but you're not allowed to give the answer any more weight than you would have no objection had been made. Please do not hold it against the lawyers if they make an objection. That's the important part of the lawyer's job. The lawyers have to let me know when there is a potential issue about the admissibility of certain evidence under our law. You must decide this case solely on the evidence presented in this courtroom. This will include the sworn testimony of witnesses and may also include any exhibits that are admitted into evidence, any facts that I tell you have been agreed to by both sides, and any facts that I indicate to you may be taken as a matter of common knowledge. Questions to witnesses, no matter how artfully phrased, are not evidence. Only the answers which you receive from the witnesses who are testifying under oath are evidence. So, if a witness is asked, isn't it true that after you learned that your uncle left you money in his will, you poisoned him? And the witness's answer is no. Based solely on that question and answer, there is no evidence that the witness has an uncle, that the uncle had a will, that the uncle left the witness money, that the witness knew that he did, or that the witness poisoned him. Any information that you may have read, heard, or seen about the case outside of the courtroom is not evidence. My instructions to you and any other comments I may make, the lawyer's openings and closing arguments, and any comments they may make are not evidence. I will emphasize this point because it's crucial to your understanding of your role. If the lawyers or I make any comments during the trial, those comments are not evidence, and your verdict must be based only on the evidence. In Massachusetts, lawyers are not allowed to make comments other than during opening statements and closing arguments. They are permitted only to ask questions, but they cannot comment on the witness's answer. If a lawyer comments, you are to disregard it. In this way, communication in the courtroom is not like everyday conversation. If a lawyer seems to agree or disagree with an answer, or if a lawyer expresses confusion or any other reaction or emotion, you are to give no weight to what that lawyer does. In the interaction between a lawyer and a witness, you may consider only the witness's testimony as evidence. In a similar way, any comment I make is not evidence. But of course, you can't disregard what I say when I provide you with instruction or direction. Remember, however, I'm the only one who can instruct you or direct you in any way. Finally, on this topic, if one of the lawyers or I refer to some part of the evidence and that does not coincide with your own recollection, it is your collective recollection which you are to follow in your deliberations. Now, in this case, I anticipate that we will go by bus to an area that you'll hear about during the trial. You may consider as evidence anything that you observe about the layout of the area. including the scene of the alleged crime when we do go there. I will give you further instructions prior to our leaving for the view. Now, in this case, I'm going to allow you to take notes. Any jurors who wish to take notes during the course of the trial, except during opening statements and closing arguments, because remember, those aren't evidence. If you wish to take notes, you may do so once the evidence begins. Notebooks and pencils will be provided to you. The notebooks will be collected each day, and they'll be locked up, and they will remain confidential, and they're destroyed at the end of the trial. Nobody sees them. You're not required to take notes. The choice is entirely up to you. Some jurors may feel that notes are helpful, particularly if the case involves many witnesses or complicated issues. Notes also can help you remember specific testimony or evidence, such as times, places, dates, names, relationships, events, distances, things like that. Other jurors may feel that note-taking is a distraction and may interfere with hearing and evaluating the evidence. If you do take notes, I suggest you keep them brief. They are not and cannot be considered official transcripts of the trial testimony. However, bear in mind that although the court reporter is recording everything that transpires here, we do not have the capability of providing you with a transcript of the testimony at the conclusion of the trial. So you'll have to rely on your own memories of the testimony, perhaps supplemented by your notes. Regardless of whether or not you take notes, please remember that how a witness testifies may be just as important as what he or she says. Therefore, your observations of the witness's appearance and demeanor on the witness stand may play an important part in your assessment of his or her credibility. Do not let note-taking distract from an appreciation of all the evidence. If you have any trouble hearing or seeing during the trial, please raise your hand or let a court officer know, and we'll make any necessary adjustments. We generally take a morning recess at around 11 o'clock or so, but if you need a break at any other time, please raise your hand and let a court officer know. We'll take a break. If you need to communicate with me during the trial, and I'm not suggesting for a minute that you need to, but if you do, please speak with the court officer or give the court officer a note to bring to me. Now, I'm going to address the issue of public interest in this case again, and the duty of this court and this jury to adhere to the rule of law, because it is so very important. John Adams famously said that we are a government of laws, not of men, and that the law must be deaf as an adder to the clamoring of the public. He meant that while public opinion about a given subject may ebb and flow, the law must be steady, reliable, and even-handed. We know that on the subject of this case, there are people advocating for one outcome or another with great intensity, but unbound by any oath or even any inclination to follow the actual evidence. The law works in a different way, and the difference is crucial to our system of justice. This jury, selected for this trial, will hear and judge the evidence. You will decide what the facts are. Where the evidence is contested, you will determine where the truth lies. Ultimately, this jury will decide whether the Commonwealth has carried its burden of proving that the defendant is guilty of any crime beyond a reasonable doubt. People outside of this building have rights, and we know that they have voices, but this trial will be decided by you, an independent jury, free from outside interference, based only upon the evidence presented in this courtroom and the law. This is the only way to ensure that every person who comes before the court receives a fair trial. It is just that simple and that important. So while public comment will likely continue, you must ignore it so that the rule of law will be upheld. Which leads me to the fact that it is very important that during this trial, until you deliberate, you must not discuss this case with anyone. This includes your family and friends, and even your fellow jurors. Nor should you allow anyone to communicate with you about any specific aspect or any aspect of this case. You must not conduct any independent research about this case, the matters in this case, and the individuals involved in this case. In other words, you must not consult the internet or do anything else to try and find out information from any source outside the confines in this courtroom. Please be very careful with your social media use. Please do not use X or Twitter, Facebook, Instagram, or Reddit. Though you may never have seen anything about this case before on your social media feed, you cannot control what may pop up. You should also remember that use of these platforms can be public and traceable, and any searches undertaken or information received by you can and likely will be discovered. So please be extremely cautious. If you inadvertently see something about this case, please disregard it and let us know. As best as you recognize them, please have no contact with any of the participants in this trial or anyone associated with either side, including the lawyers. Please do not visit any locations that may be mentioned during the trial. We'll go on a view, as I told you, and I'll discuss that with you before we go. Remember, you were instructed that you must not, and you assured us that you would not read, watch, or listen to any account of any aspect of this case in any news media, social media, or from any other source. It is critical that you follow that instruction. Finally, please continue to keep an open mind. I know that you will try this case according to the oath that you've just taken as jurors. When you took that oath, you promised that you would well and truly try the issues between the Commonwealth and the defendant according to the evidence and the law. If you follow that oath, approach this case with an open mind, and make your decisions fairly and without prejudice or bias or sympathy for anyone, then you will arrive at a true and just verdict, and that's all we ask of you. So it's now time for the opening statements. Mr. Brennan.
Thank you, Your Honor. At 6:04 a.m. on January 29, 2022, the alarm bell sounded in the Canton Fire Department. Firefighter paramedic Timothy Nuttall knew what that meant. His heart skipped a beat, he raced to his equipment, and he picked up his bag, which was meticulous. There was a sign and a signal, and then there was a voice commanding that there was cardiac arrest. The most serious of calls for a firefighter paramedic, that means that a person's heart has stopped. He didn't know who it was, he didn't know where it was. He took his bag, he had just gotten to the station, and he rushed to the ambulance. He was one of the most senior paramedics that morning. Another paramedic, Anthony Flamati, would be running this mission. He jumped in the back of the ambulance, the door shut, and they headed off to 34th Fairview Road. As they drove, firefighter Nuttall could not see anything. He couldn't hear anything other than the engine of the ambulance. He could feel it sliding across the road. It was near blizzard conditions. He calmed himself, he steadied himself. This is what the firefighters and paramedics are trained to do, to focus. And he focused on his task. He looked around the back of the ambulance to make sure all the tools were in place. The ambulance was meticulous as well. This was Anthony Flamati's ambulance, and it was well stocked. He calmed himself, and he thought about what was going to happen. What should he be looking for? What is his next steps? He played the scenarios through his mind, and every calm was above him. As the car pulled up to 34th Fairview, the ambulance, he stood at the back door, the doors open, and he stepped out into bedlam. He could hear a woman screaming and shrieking, the cold, hard air slapping on his face, and the wind, blizzard conditions swirling around him. You will hear him tell you how he trudged towards those screams in the darkness to snow. And when he got there, he saw 3 women surrounding a man lying, not moving on the ground. He walked up to the man, and he reached down, and he tried to find any signs of life, pulse, anything. And he found nothing. And he got up and he walked over to the woman, and he walked over to that defendant, Karen Reed, and he told her that he thinks that that man is gone. And then he heard the yell from Anthony Flamati, the chief, and he said, "Come back, let's go." Because you'll learn that in the cold, even if somebody's heart stops, even if they're presumed to have passed, sometimes you can still save a life. So you'll see on a dash cam video, you'll hear from testimony, he went back to that man who's John O'Keefe. He went back to him, and that crew, coordinated effort, they did everything they could to save his life. They got on their knees, they began CPR, and firefighter Nuttall will explain as he kneeled over John O'Keefe, he looked up, and the defendant approached him, and you'll see it on the video. Now, he wanted any information, because when you're trying to save someone, you want to know, are they on drugs, medication, do they have a heart condition? And he looked up at Miss Reed, and he said, what happened? And you'll hear her words to firefighter Nuttall. She said, I hit him, I hit him, I hit him. And it was at that time, through the words of the defendant, that she admitted what she had done that night, that she hit John O'Keefe. Now, those words didn't mean anything to firefighter Nuttall. They weren't in context, they didn't reconcile with the injuries, it didn't help him in his treatment, so he ignored it. Now, firefighter Nuttall is not a police officer. He is not an investigator, he is not a detective. He's a first responder. And so he takes that information that was useless to him, he continues to work on John O'Keefe, trying to save his life. You'll see the team put him on a stretcher. And when they lift him from the ground, even though there is snow accumulating, underneath John O'Keefe is simply grass, hard, brown, frozen. And beneath his body lays his cell phone. They bring him to the ambulance, and while they're bringing him to the ambulance, you see on the videos that other first responders speak to the defendant. One first responder, for that issue, will say, I hit him, oh my God, I hit him. And then she was interviewed or asked questions for background information, not a criminal investigation, just background to try to help John. And she was asked questions about his background, and during that conversation, you won't hear, see the defendant was a person by the name of Jen McCabe and a firefighter McLaughlin. And she tells Fire McLaughlin, the third first responder, I hit him. They bring Mr. O'Keefe to Good Samaritan Hospital, and his body is cold. The doctors work feverishly. They treat him, trying to save him. They try to warm his core. And unfortunately, firefighter Nuttall's first instinct was accurate. John O'Keefe passed. So why are we here today? We are here today because John O'Keefe was killed by the actions and conduct of that defendant, Karen Reed.
Sorry, I'm not going to interrupt a whole bunch, guys, because I want you to be able to watch this as close to real time as it's actually happening. But I just want to jump in really quick. I know there's Hank Brennan supporters. I know there's Hank Brennan haters, but I think you have to admit that already he has demonstrated that he's a good advocate. He's good in court. This is all extemporaneous. He doesn't have notes. He's speaking off of his own memory. He's not stuck to the podium, which I love. I was bothered by that the first time around with both attorneys, that they kind of just hung onto that podium. I don't know if that was an instruction by the judge or what, but that's been changed this time around. I think he actually even ditched the podium. And he's walking around owning the courtroom. He really is. He's dynamic. He's telling a story. He's telling a narrative. I love that he did that. You know, they call that like that medias res. I'm probably butchering the Latin, but it's this idea of jumping into the middle of the story. The story is not starting out with who is Karen Reed and how did Karen Reed meet John O'Keefe? And here's the story of their background. He starts in with the alarm bells going off for the first responder firefighters. Love that. Love that you're immediately caught up in this kind of chaos of the moment. So again, I'm going to try not to interrupt this as much as possible, but I just do think he's doing a very good job. He's got the jury definitely locked in, and he's set the theme like we talked about. What is important to do in an opening statement is set a theme, and his theme is John O'Keefe is dead because of the actions of this woman, of this defendant. And she will tell you by her own admission. Again, using her words is going to be a big thing of this trial from the Commonwealth this time around, is her own words. And he's already began with that. So, you know, not to hate on Lally, but in comparison to what we saw the first time around, this is already an entirely different trial.
You will learn through this case, through facts, science, and data, you will learn that on January 29th, 2022, when the defendant and Mr. O'Keefe were in front of 34 Fairview Road, all the way to the left side in the dark corner near a flagpole, you will learn that Mr. O'Keefe got out of the car. He got out and he stood by the side of the road after an argument with the defendant. That argument, that anger fueled by heavy intoxication, you will learn from the science and data as he stood by the side of the road, the defendant in her SUV drove away. She drove at least 35 feet away. The argument was over. It had ended. But then she stopped. She stopped. She put the Lexus into neutral, and she waited 2 seconds. And the facts and the science and data will tell you that despite the fact the argument was over, she then put the Lexus into reverse, put her foot on the gas pedal, and began to press, not 25%, not 50%, up to 75% acceleration. There was a light dusting of snow. The Lexus tire spun backwards. She went backwards at least 70 feet. She clipped John O'Keefe. He fell backwards, hit his head, broke his skull. And there he lay at the corner of Fairview Road, on the ground, lying on top of his cell phone, alone. And then the defendant will later tell that when she left, he didn't look mortally wounded. Yet he was. And she simply drove away. Now, before I tell you about the data and the facts and the science, and I walk you through that, I'd like to tell you a little bit about John O'Keefe. John O'Keefe was a young man, a local kid, very well liked, loved. John O'Keefe is the son of Peggy O'Keefe, John O'Keefe Sr., and the brother of Paul O'Keefe. Grew up in Canton, worked hard, he became a police officer. But what you're going to learn, the fact that he worked for the Boston police officer, as a Boston police officer, was just a fraction of his life. It was a small, really unimportant part, because the biggest part of John O'Keefe is he was a family man. Not in the traditional sense. You see, John O'Keefe never had biological children. John O'Keefe was never married. But John O'Keefe had a sister, and she had 2 children. And when the children were 6 and 3 years old, his sister unfortunately died. And shortly after, his sister's husband died. John O'Keefe was a help. He didn't sit by. He saw these 2 recently orphaned children, and he stepped in and he said he was going to raise them. So he put aside his career, he put aside his job, and he moved in with the children and raised them up. They were his home. They were his passions, his love. He was a new parent, successes, failures, like all parents. And he raised the children with the help of people in the community, with the help of his brother, with the help of his family. And they led a good life. Enter Karen Reed. Around COVID, the defendant and Mr. O'Keefe reacquainted, and they started a relationship. And you'll hear that even though the defendant had her own home, she was staying with Mr. O'Keefe a lot, 4, 5, 6 times a week. And to most of the world, it was a pretty good relationship. They spent time together, they did activities with the children together. She helped with providing the children, feeding the children. It was a steady relationship until about the beginning of 2022. And then things began to unravel. There was tension, there was arguments. In fact, just a few days before this incident, you'll hear that Mr. O'Keefe asked her to leave. But she wouldn't. You're going to be able to read text messages of their conversations on January 28, 2022. You will see the tension and the unraveling of the relationship. You will read about the discord between the defendant and Mr. O'Keefe. You will see that when he would ignore her calls, they would become incessant. When he would try to push away, she would come closer. You will read those text messages and you will realize that this was the beginning of the end of this relationship. That night, they decided they would go out together. I want to tell you something about data and science before we get to that night. I mentioned that underneath John's body was a cell phone. A cell phone is an amazing piece of technology. It is like a computer. It carries extraordinary data. And when they found the cell phone, the only companion to John O'Keefe that night, they studied the cell phone, and there'll be some remarkable data that you will use in this case to find the truth. I want to mention 3 different things you will find in a cell phone that are critical to this case. The first is called location data. Waze we've all heard of, Google Maps. Well, at some point that night, John put his Waze on. And Waze is like a breadcrumb that will show exactly where the phone goes second by second. It is the strongest, most accurate location data that you can have. And that night, John was using Waze. It also will have healthcare data. Healthcare data will show when somebody is moving. Sometimes it's qualified as steps, but it doesn't necessarily mean somebody's stepping. Moving their arms, walking, turning. It doesn't show what direction or how far, but it shows movement of a person. Healthcare. And the third thing, remarkably, it will be an expert in this case who found the data file on the phone, and it tracks the temperature of the cell phone battery. That will be critical to your analysis in this case, the temperature of the cell phone battery. And so with that, I want to take you back to this timeline of that night. After the discord, both the defendant and Mr. O'Keefe decided they would meet at a bar called McCarthy's. Now, McCarthy's is a local bar, a blizzard is pending, and people are getting together in a celebratory mood. They go to McCarthy's and you'll see a video of McCarthy's, and you will watch both Mr. O'Keefe, friends, and the defendant drinking alcohol. And you will count 8 vodka drinks that the defendant drank. They arrived at 8:50, they stayed till 9:45. She consumed at least 7 of those drinks in less than 2 hours. The last drink, you'll see when they leave the bar, she puts it under her jacket, and they walk out and they go to another bar to meet other friends called the Waterfall. They reach the Waterfall sometime around 10 p.m. And when they go into the Waterfall, you'll see a video. And when I said celebratory mood, you will see a group of friends of John O'Keefe, many who are friends with Karen through John, and you'll see them clapping and happy and joyous that they're there. You'll see many hugs between John O'Keefe and his friends and the defendant and many of the people there. And they spend some time together, they're drinking, and they all do a shot. So that will be at least the 8th drink within 3 hours that you consume. You will see from the data, not just the cell phone data, but there's some other very important data. And the other piece of data that goes hand in glove with the cell phone is information on the defendant's Lexus vehicle chips. You might have heard of black box in an airplane, or there's some type of event that captures a small amount of time. Well, that was captured in the defendant's Lexus. That black box information with the cell phone data will tell you everything you need to know in this case. It will bring us step by step through the entire night to the death of John O'Keefe. And so they leave the Waterfall Bar at 12:12, and you'll see that the ignition goes on to the defendant's Lexus. And both John O'Keefe and the defendant in the car, and they decide that they're going to go back to 34 Fairview Road, what we talked about earlier. They're going to go there for a get-together for one of the homeowner's sons who's having a birthday party. And so as they drive back, you will be able to follow them with this location data. When they go back to Fairview, they don't know exactly where it is, and they get lost. And so John O'Keefe makes a phone call, has a phone call with one of his friend, Jen McCabe. And during that phone call, which the defendant listens to because she recounts it, and trying to get directions, Jen McCabe tells John O'Keefe, it's near Bella's mom's house. You'll learn that Bella, or her mom, was somebody that John had dated before. And so as they make their way to Fairview, you will see there's a road that comes down like a loop and that leads to Fairview. They take a wrong turn on the loop, and then they do a 3-point turn in the driveway. You'll see the exact precise driveway they turn into because some type of acceleration movement triggered that black box in the Lexus. And that's important because that's 7 minutes before the collision. And you'll see from the waves exactly where the car was. You'll see from the black box the event of the 3-point turn in the driveway, and then a return down to Fairview. But before they get there, at 12:23, a truck is coming the other way. And the witnesses in that truck will say they blinked the lights. One of them saw a man and woman in the car, John and the defendant, and then they followed the Lexus because they were going to the same house. The truck stopped at the driveway, and the Lexus, the defendant's car, will appear because of the waves and be counted second to second, never stops. It rolls very slowly all the way to the end of the yard in the corner where there's a tree line and a flagpole. And they reach that location at 12:34:33. And they're in the car and they stay there. The truck waits, they speak to somebody in the house who comes out. The person goes back in the house and they're there for about 5 minutes. We're now down to 2 minutes before the collision. The truck leaves, and now it's just the defendant and John. And while they're waiting outside, 12:27, John gets a text from Jen McCabe, park behind us in the driveway. 12:29, she texts again, are you coming in? You'll hear that Jen McCabe and others look out the window and see the defendant's Lexus in front of the flagpole at the far end. It's snowy, it's dark, it's windy, they're waiting. You will know that John O'Keefe was in that car, that Lexus, and didn't move because his healthcare data is not moving. It's not moving until 12:31:56. At 12:31:56, he begins to move. He will have 20 seconds before he falls. 20 seconds. He gets out of the car, the Lexus, and in that 20 seconds, you'll hear that user initiated. He looks at the phone, at the text message to Jen McCabe. There's now 12:32:09. He closes the phone the last time. It will be the last time he uses that phone. From the waterfall bar, you see that he's in his back pocket. And at that time, 12:32:09, last user, he has 7 more seconds to move before he lies dormant the rest of the night. We'll also have the information from the defendant's Lexus black box. The clocks run differently. There's a 30-second variance, but it's right in the heart of that time. And you will see in the data at that time, when he makes his last movements with the phone, is when her car leaves 34 feet at least, stops, neutral, and then shoots into reverse with the tires spinning right towards him. Right where he got out. You'll know they're arguing because the next morning she tells a firefighter, I'm sad because our last moment we're fighting. She drives away. They said she's made later statements that when she left, he didn't look mortally wounded. He lied on the ground on top of his phone, light dusting of snow, the snow now picking up. And he's just there. It's 12:37. Now, when he's in the car, before he gets to Fairview, the battery temperature of that phone is 77 degrees. 77 degrees in the warm car. Now that he's been outside the car for 5 minutes, drops. She calls again at 12:36:33 and leaves a message. You'll hear it. And you will hear the anger and rage in her voice. She leaves a message. John, I fucking
This is not, this is something going on with the feed. You can see that that what do you call that news ticker at the bottom is still moving. So it's something going on with the feed. Sorry, guys. Great pose on his face, though. I mean, let's talk a little bit about how he's doing, I guess, while we have this pause, and I hope this is able to get fixed, because that would be real trouble. Maybe, Kaylin, if you could look to see if there's another feed working or something, or if it's paused on other people's feeds like it is on ours, but I don't think it's a problem.
Cell phone blocks. It's almost 60 degrees. 12:59, the defendant leaves another message.
God, I hope this doesn't become a problem. It's probably so many people watching, to be quite honest. But I will say I'm impressed with. It is very hard. It is very hard to give a speech
Go back to him. She did not leave.
entirely from memory like he's doing right now.
No answer.
Hold on, guys. I think we're trying to work on finding a different feed.
Walking the street, passing out. But then she wakes. 5 o'clock, she is frantic. She wakes up John's niece, and she is unintelligible. She is yelling, she's screaming, she asks her niece to call Jen McCabe. She calls Jen McCabe, and you'll hear Jen McCabe recount. Either deep sleep, she wakes up and she hears, Jen, 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 screaming Jen's name. John's dead. Hangs up the phone. Jen McCabe.
Oh, come
Go
on.
down. And then she, what's going on? And she told, well, I left him at the waterfall at the beginning of the cover. She tells Jen McCabe, I left him at the waterfall. Jen calls back and says, he saw you up front. You did leave him at the waterfall. She hangs up. He then minutes later calls another person, Terry Roberts, a friend of John O'Keefe. Someone who's not friends with the defendant, but they know because they helped raise the kids when they interacted. She had nothing to do with the night before, wasn't at the bars, was home with her family. She calls her and says, I think John got hit by a plow. I think he's dead. Now Terry, with that information, calls 911. She calls hospitals, you can hear her voice. She's concerned. Not him. And then she gets another call from the defendant. And she tells the defendant, come to my house. I will help you look for him. And the defendant says, I was so drunk last night, I don't remember anything. Waiting for her to arrive, she learns she doesn't arrive. Instead, the defendant goes to Jen McCabe's house. Terry Roberts, the other friend, then goes to Jen McCabe's house, pulls behind the car. And when she does, she's on Bluetooth, and she can hear the defendant say, my taillight's broken, my taillight's broken. And she looks, and the snow pack in the right taillight, she can see a piece of the taillight missing. The defendant desperately wants to go to 34th Fairview Road, but Terry Roberts takes over and says, we're going to go back to John's house. Maybe he's in the house and you didn't see him. So both cars, driven by Terry Roberts and then Jen McCabe, with the defendant, go back to John O'Keefe's house. You'll see a ring video where you see them go into the house and they look around, and you'll hear about the woman, Jen and Terry, enlisted into this task. Look for John O'Keefe, they cannot find him. And then when Terry Roberts comes into a room, she sees, rather than looking, the defendant simply standing there, staring at the wall. At that point, the defendant insists they got to go back to Fairview Road. They decide to take one car. Terry Roberts is taking charge. She's going to drive. They leave Miss Reed's Lexus in John O'Keefe's driveway, and they drive back towards 34th Fairview Road. You'll hear it is blizzard-like conditions. It is dark. They can barely see a thing. And when they get close to the edge of 34th Fairview, you hear the defendant start to scream, there he is. Both women look and they can't see anything. She starts kicking the door. The defendant's kicking the door. Let me out. Terry Roberts stops the car and lets her out, and she sees the defendant run exactly to where John O'Keefe is in the darkness, just where she left him. Terry gets out of the car, starts to walk towards where the defendant is, and she sees the defendant lying on a body. She can't tell who it is because the face is still covered with snow. And she comes over and looks, and she wipes off the snow from John O'Keefe's face. She realizes it's one of her best friends in the world, is John O'Keefe. And she starts trying to do first aid. They start to move him, and coincidentally at 6:06, when they start to move him, the cold air hits that cell phone battery. It drops from 50 to 43 degrees. And they try, Jen McCabe calls 911. And that's when a police officer arrives, firefighter Nuttall and his crew. And when they lift him, that cell phone battery that is shut down to 37 degrees, Terry Roberts picks it up and puts it in her pocket, and it immediately starts to warm as she moves to help get a data, showing movement starts again. At that point, nobody knows what happened. The Canton Police Department come. You can see the police cars and cruisers. They're not sure, so they look in the area where John's body is and find a glass from the bar near his body. They find blood spots. They try to put the blood spots in plastic containers. They don't know what they're looking for at this point. There's no information. They don't believe or know that there's a crime. They just know that John O'Keefe somehow ended up here with the broken glass and the blood. And so that morning, you can see the work.
All right, guys. Sorry about this.
Out of the news, and they go to the hospital. They go to the Good Samaritan Hospital, and Terry Roberts is walking, and Peggy O'Keefe is going to go see her son.
If we keep having problems with this, I think we're going to switch over to another feed. So bear with it.
And as she walks down the hall, Karen Reed is also in the hospital. See, there was some reports of maybe she was upset or suicidal, so they sectioned her. They put her in for evaluation to make sure she was safe. You hear Peggy O'Keefe tell her she walked.
What a pain.
As she walked by Karen Reed, she stopped and she said, "Karen, what happened?" And you hear that Karen was excited and yelling, "He could be dead." She stops her excitement. What's going? Doesn't say a word. Peggy pays respects to her son, and then she has to go back home because she has to help her children. Now, while she's out, the Canton Police Department sent an officer to the house to make sure the children are safe because they're alone if they're home. And when the officer pulls in, he doesn't notice anything, but you'll see in the dash cam video notices something. That tail light has a big missing piece to it. They can't find the children. Ultimately, Peggy comes home, a friend can take it down, and they bring the nephew home, and he is distraught. And then Peggy hears a knock on the door. It is the defendant and her father. They want to come in. They come in, no condolences to Peggy. And they ask, "Can we go upstairs to John's room?" And she's busy consoling her grandson. They go upstairs, they're upstairs for about 15 minutes. They come down, and quickly they leave. Now they got there from the defendant's father, drove his wife and the father to that house. But when they leave, they take two cars. They take the Lexus with the broken taillight with them back to the defendant's father's house. And you will learn that when police start getting some of the information, they learn about the broken taillight, they learn information that she had told people that she had hit him. They went down to see her. And on their way down, they decided they would get a warrant to take the Lexus. When they get down, you'll hear from Trooper Buchanan. He took a look and you can see the missing taillight. They went in and spoke briefly to the defendant. They took the car and brought it back to Canton. And so, what to learn from the forensic evidence that will help with the science and data is that not only was the cell phone left behind, but also around that area, broken taillight was littered around John O'Keefe's body. Littered around that area. When they got into the hospital, they noticed there was a shoe missing. As time went by, snow melted, they dug the excavations, they found the shoe on the border between the street and the grass. We learned days later when they did a plant excavation, they found his hat frozen to the ground.
Oh, this is becoming.
Over the course.
Okay, guys. Sorry about this. I think we are going
to,
because I don't want you to miss out on this stuff. So Kaylin's going to work on that really quickly. And while she's doing that, we can talk about how this is going super quickly. Brennan has been rubbing a lot of people the wrong way. I think that he's got a lot of people who he does not have all that many fans from the way that he's conducted a lot of these hearings. I know a lot of people find him to be annoying. He's got a bizarre kind of affect to him and everything. I'm not all that bothered by him, quite honestly. But I'll tell you what, this is impressive, and that's hard to deny. It is impressive when someone can speak off of the top of their head as clearly as he has been doing during this case, during this opening statement. So I am impressed with his command of the facts. I am impressed with his ability to remember this entire opening statement. And I think it is listen, it's not knocking me out of my seat, but it is an impressive opening statement as far as speaking off of his, extemporaneously, knowing the facts and telling a narrative and developing a theme. Kaylin, do you have is it matched up to where we left off? That's just the only thing is I don't want to, okay, she's going to take a second to do that. I don't want us to miss anything. So we might be just a few seconds behind. But this is just good advocacy. This is just good appreciation for an attorney who knows their job, who knows how to give an opening statement. Britt Black says, "Man, that's okay. We're not all gonna see the same thing on all of this." He listen. Like I said, here's the one thing. There are very few defense attorneys that could follow an opening statement like this and recapture the room and get everyone back in the palm of their hands. It just so happens to be that one of those defense attorneys is sitting in this courtroom. Alan Jackson is not somebody you want to follow, and there are very few people that Alan Jackson has any trouble following. And so what you're about to see is, I think, he's not going to have he's not going to have any issues following this act. He's going to come up, bring some energy back into the courtroom, and do as good, if not a better job of having a command of the facts. I am just saying, not to compare everything to the first trial, but this is certainly a different prosecution. Already we are seeing that this second time around. How are we doing, Kayla? Are we ready to go? Okay. Why don't you go ahead and you gotta add the feed, right? Go ahead. Oh, I gotta remove my screen. What would I do here? Okay. Can you guys hear that okay? Let us know.
On a little berm on the border between the street. We learned days later when they did a plant excavation, they found his hat frozen to the ground. Ultimately, they would find over the course of 10 days that the snow melted almost all every piece of that broken tail light in that area. His hat, his sneaker, with something of this early called trace evidence. You'll learn on the back of her Lexus, around the taillight area, is John's DNA, and stuck to the side, grasping one last piece of John O'Keefe's hair. Now, John O'Keefe fell backwards and hit his head after he was clipped by a car. And you're going to hear from a very renowned doctor and neurosurgeon who has treated thousands and thousands of head injuries. And the wound on the back of the head, when he fell backwards, on the cracked skull, it's called a basal fracture. It created an injury called counter-coup. After he was put by a car and fell backwards and hit his head on that hard rock ground, remember there's no snow, it's just a dusting at this point. The back of his brain hits the back of his skull and bounces up. When it bounces up, it leaves marks showing that impact. And this neurosurgeon will tell you, he treated thousands of patients, that this injury, to a reasonable degree of medical certainty, is counter-coup caused by falling backwards and hitting your head. When the medical examiner for the state looked at it, they generally said blunt force trauma, they had it undetermined. So we wanted to the renowned neurosurgeon who does exactly this. You're also going to hear from an active reconstruction named Doug Welch. He does not work for the state police or local police. He was hired to take a look at this case and the data. He will come in and explain to you exactly what I talked about, how the data from that black box coincides.
Go ahead and pause it, Caleb. Sorry about this, guys. We're just trying to find the best feed that we can. You know, we're dealing with the difficult. I know I hear everybody saying it's very low sound. That's that we had it maxed out. So Kaylin's working on trying to find an even better one now. Just give us a second to put that together. But
he was the lead investigator on this case.
Hold on.
And he was talking about
a campaign, exactly what I talked about.
Sorry. Okay. And we're wrapping up towards the end. So we're going to get into Alan's opening statements pretty soon here. But yeah, I mean, if you want to grade this, if you want to give it a grade, and I removed it from the stage, Kaylin. And you guys might want to adjust your volume by the time we go back, because who knows what this next volume is going to sound like. All right.
Now, John O'Keefe fell backwards and hit his head after he was clipped by a car. And you're going to hear from a very renowned doctor and neurosurgeon who has treated thousands and thousands of head injuries. And the wound on the back of the head, when he fell backwards, on the cracked skull, it's called a basal fracture. It created an injury called counter-coup. After he was put by a car and fell backwards and hit his head on that hard rock ground, remember there's no snow, it's just a dusting at this point. The back of his brain hits the back of his skull and bounces up. When it bounces up, it leaves marks showing that impact. And this neurosurgeon will tell you, he treated thousands of patients, that this injury, to a reasonable degree of medical certainty, is counter-coup caused by falling backwards and hitting your head. When the medical examiner for the state looked at it, they generally said blunt force trauma, they had it undetermined. So we brought it to the renowned neurosurgeon who does exactly this. You're also going to hear from an active reconstruction named Doug Welch. He does not work for the state police or local police. He was hired to take a look at this case and the data. He will come in and explain to you exactly what I talked about, how the data from that black box coincides with the cell phone and the movements of the car, the moments before, during, and after the defendant struck John O'Keefe with their car. Now, just a few more things I want to share with you. There are 3 charges against the defendant in this case. The first one, second-degree murder. When most people hear murder, they instantly think shooting somebody, stabbing somebody, bringing with a premeditation. Or I will instruct you on the law. I'm not going to trample in that area, but I can tell you clearly we are not was she engaged in an intentional act, driving back at him at that speed in the storm, in the darkness, knowing that he had just gotten out of her Lexus. She intended that act would cause plain, strong likelihood of death. That's what will keep second-degree murder. Also, operating under the influence of alcohol, manslaughter will prove that she drove her Lexus recklessly. She hit John O'Keefe, and because she hit him and he fell back, she caused his death. The third charge is the scene act knowingly causing death. Again, she hit Mr. O'Keefe with a car. She knew he was injured. She left him behind. And he died. That's the whole group. This case will come down to the science and the data. The science and the data that cell phone is the best of historians. It doesn't suffer from intoxication. It doesn't suffer from memory loss. It doesn't suffer from emotion, pride, or prejudice. It is facts. It is data. And that facts and data will lead you to the truth in this case. But after Ms. Reed was charged, she began what you'll learn as a campaign to make public statements. 2020 Nightline, Fox 25, a documentary. And we've had an opportunity to get many of her statements in the footage, and we're going to show much of it. And her statements to you will confirm what you already know from the science and the data, what you will already conclude from the facts independent about what she did that night. Her word is simply confirmed that her judgment is sound. And you're going to hear from her own lips and many of her statements, her admissions to extraordinary intoxications, her admissions to driving the Lexus, her admissions to being angry at John that night. And as they say, her admissions that she told. Like to play for you clip one. You're going to hear the first of the statements that she made after she was charged.
I mean, I didn't think I hit him, but could I have clipped him? Could I have tagged him in the knee and incapacitated him? He didn't look mortally wounded as far as I could see, but could I have done something that knocked him out and in his drunkenness and in the cold didn't come to again?
And this would have been the moment you dropped him off at the party.
Yeah, would have had to.
Ladies and gentlemen, I simply ask you to follow the evidence, follow the science, follow the data. Ignore speculation, surmise, conjecture. Stay true to the evidence. It will lead you to the truth. That on January 29, 2022, a very intoxicated defendant was angry and arguing about the relationship with John O'Keefe. And after the fight was over, she left, but she brought the fight back to him in the form of her SUV. She clipped him, he fell backwards, he broke his head, and then this man who helped, a lifetime of help, was left at the corner of that yard, left to die with no help. The facts, the data, and the evidence will bring you to the truth, and the defendant's own words will confirm everything you've already concluded.
All right, thank you, Mr. Jackson.
All right. Okay, first of all, hope that sound is better for you guys. I know the volume is not ideal, but I think we'll put up with a little bit less volume as long as we can have a clean feed. So thank you guys for bearing with us, and thank you for putting up with that. And it was the one time that we had a technical difficulty that wasn't my fault. So I'm always happy when that takes place. And Kaylin's been such a trooper. So round of applause to Kaylin for being in full panic mode in the background, but figuring everything out for us. So thank you, Kaylin. Just some quick thoughts on this. Again, putting the first trial out of your mind, starting this fresh, just giving an impression. That was a very serviceable opening statement. like I said, Hank Brennan is not the type of guy that's going to light the world on fire. This is never going to be one of those things that you're going to walk away and go, wow, that was one of the most dynamic speakers I've ever seen in my whole life. He's got a kind of affect about him that's very kind of straight-laced, very matter-of-fact, very, nearly monotone. But he's walking around the courtroom. He owns the courtroom. There's a certain amount of dynamic energy about that presentation. He certainly knows the facts. He's demonstrating an absolute command of the facts to the jury. That's an important thing to be able to do, to be able to show the jury that you know this case very well, to instill a sense of confidence in you as a prosecutor, that you know your case so well you don't even need notes. And that was impressive, to the point that he's giving exact times. He's talking about, at 12:52 X happened, at 12:56 such and such happens. That shows somebody who is thoroughly well-versed on a case, and that means something to a jury. So for all those reasons, the moving about the courtroom, the extemporaneous nature of it, the command of the facts, the theory, the story that he told, all very good. And then he strikes this theme, the idea that this case will be dictated by the science and the data. And he talked about the cell phone and the black box being the two most important elements. Again, important for the prosecution to highlight that, because the defense case is going to be very different. The defense case is going to be about, yes, science and data, but also about conspiracy and cover-up and witnesses and motivations and everything else. And he's saying, I want you to see past all of that and see the science and the data. But I'll tell you what, the biggest difference to me, and the biggest factor, and in my view, some of the most powerful evidence that can ever be presented to a jury, is words out of the defendant's own mouth. I don't care. I could have had a very weak case as a prosecutor, but you tell me that I have the defendant's admission on tape, that's easy. I'll take that to trial any day. Now, it's going to be argued by the defense that none of these are admissions, but that was a very powerful piece of video that he just played. And it is certainly going to put the defense on their heels to unwind what exactly she meant by that. Her lawyers are less than thrilled. You're absolutely right, Britt Black. Her lawyers are way less than thrilled that they have to deal with those statements. Is there an explanation they're going to provide? Sure. Are they going to try to unwind it? Absolutely. But already, if you're unwinding and explaining, that puts you in a far less advantageous position. That, if I'm a juror and I know nothing about this, and I watch and she gave an interview and she's saying things like, I was wondering, had he been mortally wounded? I was wondering that. Already, if you're talking about the purpose of opening statement to set a theme and a narrative and a lens in which the jurors should view the rest of the case laying out, that's very powerful stuff. So viewing this with fresh eyes as much as I possibly can, I would say that was a very good opening statement, but the most powerful thing about it was the words that came out of the defendant's own mouth. And this time around, that to me is going to be one of the difference makers, is how much will Brennan use the words out of her own mouth. But nothing she said convinced me of anything yet. Very good, Kathy. You're right. And we shouldn't be at that point. We haven't really heard evidence. And that one statement doesn't really mean a whole lot without the context of any kind of evidence to support it. So that all being said, are we ready to begin? Kaylin? All right. Kaylin's our champion today. I appreciate you. Let's get this going now. See how Alan responds to all
I
that.
have just a moment to readjust.
Sure, the court officers will be kind enough to help you.
May I, Your Honor? The evidence in this case will establish above everything else 3 points. There was no collision with John O'Keefe. There was no collision. There was no collision. John O'Keefe did not die from being hit by a vehicle, period. The facts will show that. The evidence will show that. The data will show that. The science will show that. And the experts will tell you that. You'll learn that the Commonwealth has pinned its entire case on a brazen and a flawed assertion that is untethered, unconnected to the facts and to the evidence. And their assertion is contrary to science. Because at the end of the day, folks, there was no collision with John O'Keefe. So how did we end up here? How does Karen Reed end up sitting in that chair on trial for an event that literally never happened? Well, the evidence is going to explain it. And it can be summed up in the following text message at the very beginning of this investigation. A text message of a now fired Massachusetts State Police officer named Michael Proctor. He was the lead investigator on this case, and he was talking about a fellow officer, a fellow cop who owned the property where John O'Keefe's body was found. Text message with a buddy. Question: is the homeowner going to catch any shit? Answer: nope. He's a Boston cop too. That quote defines the lack of integrity of the Commonwealth's entire case, its entire investigation, and this prosecution. During the course of this trial, you'll learn much more about Mr. Proctor, why he said that, and what it really means. What you'll see and hear in this courtroom in the coming weeks is not just a story of a tragic loss. And make no mistake, John O'Keefe's death is and was a tragic loss. But the story you'll hear is about an investigation that was riddled with errors from the beginning, a rush to judgment, conflicted and corrupted from the start. Corrupted by bias, corrupted by incompetence, and corrupted by deceit. Finally, it was corrupted by a deliberate effort to avoid and to cover up the very truth that you are seeking. You'll find when you hear the evidence that the Commonwealth's case is the literal definition of reasonable doubt. They won't be able to talk their way out of it. They won't be able to explain their way out of it. They won't be able to excuse their way out of it. And they can't meet their extreme burden of proof, which the court will tell you is beyond any and all reasonable doubt and to a moral certainty. Members of the jury, Karen Reed found John O'Keefe dead on the front lawn of a Boston police officer, Brian Albert, at 6 a.m. on January 29th, 2022. Picture the scene. Blood-curdling screams, ambulances, emergency lights on, fire engines, ladder trucks, paramedics, patrol vehicles, patrol cruisers, police officers, first responders, firefighters, all swarming all over Brian Albert's lawn, literally feet under his bedroom window. Yet Brian Albert, a sworn peace officer, a first responder himself, never came outside. Never went outside to see what the chaos was about, never went outside to see if he could assist a man in need, never walked outside his house to see if he could help a fallen fellow officer on his own front lawn. More shockingly, you'll learn that lead investigator for the Massachusetts Police, Michael Proctor, never set foot inside Brian Albert's house that day. Never engaged in any investigation inside that house that day, even though a party with much alcohol had just occurred in that house, and even though a Boston police officer was found dead or dying just mere feet from the front door on that lawn. He never secured the crime scene, never separated and secured witnesses. He never properly collected evidence. He never secured the evidence. He never searched for signs of a struggle inside or outside the home. He never properly canvassed the neighborhood. Michael Proctor never did any of these things, even though fellow officers of Michael Proctor's actually mentioned, in their words, not mine, that it looked like John O'Keefe may have been, quote, in a fight.
Okay,
You'll have questions about that conduct.
All right. This is, I mean, you know, this is why I say he's as good as he is. He immediately changes the energy in the room. I mean, that's fairly obvious. Again, trying to view this case as much as you can with objective new eyes. The energy in the room has taken a shift. This is not a defense that is afraid. This is not a defense that is apologetic. This is not a defense that is on the retreat. This is a defense that is aggressive and in your face and immediately going to establish a different type of narrative. Well done, Alan. I have to give that to him. Absolutely. There was no collision. Love that. Love that from the start, because that is the entire case, right? Yeah, you can talk about being framed. You can talk about cover-ups. You can talk about third-party culpability. But this whole case comes down to, was he hit by a vehicle or wasn't he? And if he wasn't hit by a vehicle, none of the everything else matters. None of it matters. It has to start with that central square one inception point. John O'Keefe was not involved in a collision. And we're going to prove that to you. And then one very clever thing, and I hope you guys picked this up, he did. He said, how are we going to do that? Through science and data. So he's using the prosecution's own words against them, own arguments against them. How am I going to prove to you he wasn't hit by a vehicle? Oh, by those terms that you've heard a few times already this morning, the science and the data. That's how I'm going to prove it to you. And then we talked about this beforehand. You got to have a bad guy? Fine, we'll give you a bad guy. The bad guy is the lack of integrity that was of the police investigation that was riddled with errors and a rush to judgment, all centered around a person named Michael Proctor. So again, poor Trooper Proctor going to be brought up from the grave that he was buried in the first trial, and strung out in this trial as the villain. It's the police investigation, it's the sloppiness, the rush to judgment, the errors, but it all centers around a person by the name of Michael Proctor. So already establishing a theme, already flipping the energy in the room and the narrative. And it's well done. I mean, no surprise. No one was expecting anything less. So, I mean, buckle up, everybody. This is going to be a really good trial as far as I think really good advocacy on both sides. Sini doesn't seem to think so, but I think it's going to be a very good advocacy on both sides. You have some very good attorneys with very different styles, but both very well prepared. Go ahead, Kaylin. Sorry, I'm gonna hush up now.
During the course of this trial, you'll find that the Commonwealth will not have answers. You'll see from the evidence in this case that this case carries a malignancy, one that is spread through the investigation, it's spread through the prosecution from the very start, from the jump. A cancer that cannot be cut out, a cancer that cannot be cured. And that cancer has a name. His name is Michael Proctor. Now, you didn't hear his name in the prosecution's opening statement. Not once. And I suspect that was probably by design. But make no mistake about it. The evidence will show in this case that Michael Proctor is the very definition of the Commonwealth's case. And he's also their Achilles heel. He was the lead investigator on the case officer, the architect of the entire prosecution. You'll learn there's not a single part of this case, folks, not a single part that he didn't touch, that he didn't direct, that he didn't orchestrate personally. every single bit of it has his fingerprints on it. You'll learn that Michael Proctor was a longtime family friend of the Alberts. And he's been disgraced by his own agency, not by us, by the Massachusetts State Police. Investigated, suspended, and fired. The evidence will show that Massachusetts State Police found him guilty, found Michael Proctor guilty of bringing dishonor to the department for his conduct, not in some other case, not in some tangential case, in this case. The investigation of Karen Reed. Conduct that included bias in favor of his friends, the all-powerful Albert family, and bias against my client, Miss Reed, the outsider. You have any idea how hard it is for a state trooper to get fired? The evidence is going to show that Michael Proctor earned it. Every bit of it. You'll hear that within hours of a Boston police officer being found dead on Brian Albert's lawn, Michael Proctor, the lead investigator, who had investigated exactly nothing up to this point, right at the beginning, made an early pronouncement that Brian Albert himself was not going to, quote, catch any shit, end quote. And that was for one reason and one reason only. He's a Boston cop. The evidence will show that Michael Proctor made this statement in a text conversation with his high school buddies. A text he never thought would see the light of day, certainly never thought we would get a hold of. And when he thought no one was looking, he actually said the quiet part out loud. He's a cop too. We'll give him a pass. You'll learn that in Michael Proctor's world, rank has its privileges. And the evidence will show that's privileges that you don't get and I don't get. But apparently a Boston police officer, Brian Albert, and his friends, they do get. You'll learn that in Michael Proctor's world, he didn't care about finding the truth. In his world, his priority was to protect the brotherhood, to protect that blue wall, to protect his friends who were at the Alberts' house that night. I want to take a step back, if I could, and spend the next few minutes talking a little bit more detail about what the actual facts in this case will show, not based on speculation, not based on surmise, not based on guesswork or conjecture, but the actual true facts that you will learn through the course of this trial. On January 28th, 2022, it was a Friday night. John and Karen had made plans to meet up with friends for drinks. It was a happy and normal night for them. They were affectionate, they were loving, they were in good spirits, nothing out of the ordinary. They started at a local watering hole called C.F. McCarthy's. You've heard that name before and you'll hear it again. And eventually they made their way over to the Waterfall Bar and Grill, another bar where they ended up. When they got to the Waterfall Bar and Grill, the Albert family was already there, already heavily drinking. You'll learn that this was no ordinary family, the Alberts. The Albert family was a well-known Canton family. Some might even describe them as a very powerful Canton family. Brian Albert was there at the waterfall. You'll hear that he's a longtime Boston police officer. His wife, Nicole Albert, was there with him. His brother, Chris Albert, a powerful Canton politician. He sits on the select board. The select board actually governs the police department, the Canton PD. He was there. His wife, Julie Albert, was there. Their daughter, Caitlin Albert, was there. His sister-in-law, Jennifer McCabe, was there. Her husband, Matt McCabe, was also there. They were all there drinking before John and before Karen ever arrived. You'll learn that a man by the name of Brian Higgins, also a law enforcement officer and longtime friend, longtime pal of Brian Albert, he was also there. And the two of them, the two Bryans, had been drinking most of the night together. You'll see video footage from the waterfall, which will show you that Karen and John were happy. They were affectionate. They were caring. They were loving. Just business as usual, out on a date on a Friday night. But that exact same video footage which lead investigator Michael Proctor plainly chose to ignore that video footage. It paints a very different picture of Brian Higgins. You'll learn that Higgins had romantic designs for Karen. That becomes important. Brian Higgins had engaged Karen in flirtatious texts, but days earlier, she had put a stop to it. She had ghosted him, in common parlance. In other words, just ignored him. The evidence will show that the first time he saw her and was in her presence after being rejected by her was when she walked into the Waterfall Bar and Grill along with her boyfriend, John O'Keefe. At 11:58 p.m., just minutes before John ultimately arrived at the Albert residence, you'll see a video at the Waterfall of an unsettling interaction, troubling interaction between Brian Higgins and John O'Keefe. And unlike the lead investigator, Michael Proctor, in this case, you won't ignore that evidence. As the bar was closing around 12 midnight, the Alberts invited everybody back to their house for a get-together to just keep the night going. And you'll learn that Karen and John ultimately pulled up to the house. They got out of the SUV to make sure they had the right address. You see, neither John nor Karen had ever been to 34 Fairview. They weren't even sure they were at the right address. And the evidence will establish that John got out of the SUV and went into the house. Let me say that again. The facts unequivocally, the data, the science, the witnesses will all unequivocally establish that John O'Keefe went into the Albert home that night. Eyewitnesses and forensic data will establish that fact. When he didn't come back out, you'll learn that Karen grew increasingly frustrated. She got upset. She was left alone in a car in the cold, in the middle of the night, with the car idling. John had gone into the house. She expected him to come right back out. And when he didn't, seconds turned into minutes, and minutes started to clock away. She left John a voicemail, then another voicemail, voicemail after voicemail after voicemail, text messages. But he was unresponsive. He didn't pick up a single call. He didn't respond to a single text. The longer he didn't respond, the more upset she got. The Commonwealth will intimate, as they already have in their opening statement, that these voicemails are evidence that the two were fighting. The actual evidence in this case, however, will show the exact opposite. You'll hear that Karen was very agitated. You'll hear some voicemails where she's swearing. You'll hear voicemails where she calls him names. There's name calling. But you'll also hear the context of those voicemails. And every single one of those voicemails was left for John after he failed to come back out of the house, after he failed to respond to her voicemails and to her texts. Karen believed John had just left her sitting there, grabbed a beer, was partying with his friends. The evidence will actually show that John and Karen never had a crossword, not a single crossword that entire evening before he left that SUV and went inside the house. And you will learn what Karen had absolutely no way of knowing at the time. It wasn't that he wouldn't respond to her. It's that he couldn't respond to her. And the evidence will show you why. Let's talk about that. We'll introduce you to a doctor named Elizabeth Lopesada, a renowned forensic pathologist, a medical examiner, and a professor at Brown University. She will tell you that the injury to the back of John's head, first of all, was immediately incapacitating. And that has meaning. At the moment he suffered that fatal head injury, he couldn't walk, talk, grab his phone, cry for help, nothing. He was completely incapacitated, completely unconscious from the moment he suffered that injury. He was completely still and incapable of interacting with anyone or anything. But the doctor will tell you something more, and just as important. She'll tell you that John O'Keefe did not suffer from hypothermia, as the Commonwealth will undoubtedly allege. His body showed no signs of it. No frostbite, no cold-induced injuries to his organs, no damage based on cold or frost. Ladies and gentlemen, the scientific evidence and the medical evidence will establish that John O'Keefe had to be injured somewhere else, somewhere warmer, and his body had to have been moved out into the cold. And that's where ultimately at 6 a.m., Karen found him the next morning. You will learn that John did not have a single injury consistent with being hit by a car. Let me say that again. The evidence will establish that John did not suffer a single injury on his body consistent with having been hit by a car. Not one. You'll learn that John's torso, his ribs, his chest, his arms, his hips, his legs, his knees, his ankles, his feet, all of them, no broken bones, no fractures, no contusions, no torn ligaments, no internal injuries, not even a bruise. Nothing consistent with a car accident, despite the Commonwealth's contention that he was slammed into by a 6,000-pound SUV. Not a bruise. Dr. LaPosada will tell you with medical certainty that, in fact, John was not struck by a vehicle. Medically and scientifically, he could not have been struck by a vehicle. Therefore, as I said, there was no collision. She will tell you that the patterned abrasions on John's right arm, the patterned abrasions you see over my left shoulder, they're not the result of being struck by a car or a taillight. You'll take one look at these injuries and you'll agree with Dr. LaPosada. The evidence will show that these injuries are from an animal, like a large dog, like the large dog that was inside the Albert house that night. You'll learn that Brian Albert has actually admitted that his large dog, the family dog, is, quote, not good with strangers. And of course, John, never having been to the house before, was a stranger that night. You'll also learn that oddly, very oddly, after having their family pet for 7 years, a short time after this incident, the Alberts got rid of that dog. They called it rehoming her. But she was gone. Dr. LaPosada will also tell you that the injury to John's head was not the result of falling backward onto a flat lawn, cold or otherwise. Rather, Dr. LaPosada will tell you with medical certainty that the injury pattern to his scalp was produced by an impact from a raised or ledged surface, a surface that does not exist on Brian Albert's front lawn where John was found. The medical evidence will establish no hypothermia, no injuries from a car strike, no collision with a motor vehicle. And forensic analysis of John's cell phone, Mr. Brennan mentioned that in his opening statement. The Commonwealth's own expert will ultimately support the exact facts that I just told you, including the temperature data. John O'Keefe was injured someplace warmer, and he was moved. That alone is reasonable doubt, but there's much more. You'll also learn that there were many people at that after-hours gathering at Brian Albert's house who would have left by the front door just feet from where John O'Keefe's body would have ultimately been had he actually been there right after 12:30 a.m., which is what the Commonwealth's claim is. There were nearly a dozen people who walked out that front door directly adjacent to the precise spot where John O'Keefe would have been lying. Not a single person, not one, not a single person saw a 6'2", 216-pound man laying sprawled in the front lawn in dark clothing on a light white dusting of snow. Not one. Then the evidence will also show that every one of those same people drove by that same spot, not walked by it, drove by it to leave the house, and still not one of them saw John laying in the yard when they left between 1 a.m. and 2 a.m. in the morning. But you know who else you'll find never saw a body on that lawn? The snowplow driver, a completely independent witness charged with plowing the streets in Canton that night. You'll hear that Michael Proctor, oh, he's not done yet, Mr. Proctor. You'll hear that Michael Proctor wrote a report where he claimed that Fairview had not been plowed that night. You'll learn that that was completely false. That was a lie. Michael Proctor did not want any more witnesses. He didn't want the truth. And he falsely claimed that the road was never plowed. You'll learn that he wouldn't look for the plow driver, but we did. And we found, and we'll introduce you to, Brian Loughran. He plowed Fairview that night, and what he's going to tell you is that there was no body on that lawn at 2:30 in the morning. You'll learn that Brian Loughran passed by 34 Fairview, traveling right next to Brian Albert's front yard, and at 2:30 a.m., John O'Keefe was not there. But you'll see that the plow driver also provides some other troubling information, troubling testimony for the Commonwealth. You'll learn that after making that pass at 2:30 a.m., he showed up with his plow an hour later. He stopped at the entrance of Fairview. He was looking up Fairview to decide whether or not to plow it, but he saw an obstruction. At 3:30 a.m., he looked down the street, and in the very spot precisely where Karen would later find John's body laying at 6 a.m., there was a car parked in front of it, a Ford Edge. You're going to ask yourself, who's moving a car at 3:30 in the morning into a blizzard on the side of the road? You'll learn that Michael Proctor, the lead investigator, intentionally ignored this fact as well. He did no investigation to find out who owned a Ford Edge, but again, we did. And the evidence will establish that Ford Edge happens to be a favorite model of the Albert family. More than one Albert owned a Ford Edge at the time. You'll learn that those facts will add to the mounting and the overwhelming evidence that there was no collision and John O'Keefe's body was moved onto that lawn. You'll find that this is yet additional reasonable doubt in the case. You'll be introduced to science and physics, even from the Commonwealth's own experts. That science will establish that Karen Reed's SUV was not damaged by hitting a pedestrian, and conversely, John O'Keefe's injuries did not come from being struck by a vehicle. The Commonwealth mentioned triggering events, but what you'll actually learn from the experts, some of them the Commonwealth's own experts, is that a triggering event is not evidence of an accident. It does not evidence a collision. That's why we're here, a collision. And there's no evidence of one, zero. You'll also find that those exact sort of triggering events that the Commonwealth will rely on are relatively commonplace on Karen's SUV, and none of them are associated with a claim of a collision. Folks, the science will not lie, and the physics cannot lie. And that science will tell you with certainty there was no collision with John O'Keefe. You'll add that to that rising mountain of reasonable doubt. I want to take you back to the night in question, January 29th, for just a few minutes. Remember, Karen had gone home after dropping off John and John walking to the house. While Karen was asleep at home with John's 13-year-old niece, what were the people who had been at Brian Albert's house that night? What were they doing? While she slept, what you'll find and what the evidence will show is that they were extremely busy. You'll learn that after a long night of heavy drinking, Brian Higgins left the Albert residence, but he didn't drive home. Rather, he drove over to the Canton Police Department, where he kept an office at about 1:25 a.m. Not a Canton police officer, but he kept an office there. Why go back to his office at 1:25 a.m.? Why go back to the Canton Police Department at 1:25 in the morning on the night of a blizzard? You'll learn that while there, Higgins made a call at 1:30 a.m. Higgins will later deny that he made that call. You'll find that curious. And his explanation for that late night visit to Canton PD, you'll find that it changes nearly every time he's asked about it. You'll learn that after everyone left Brian Albert's house, Brian Albert actually claimed he had no contact with anybody else except his wife. No contact. Until he woke up the next morning. So he says. Then you'll learn that that too is a complete lie. His phone records establish that he placed a call to none other than Brian Higgins at 2:22 a.m. shortly after Higgins completed that late night visit over to Canton PD. You'll wonder, what did they possibly need to talk about at 2:22 a.m. that night. The evidence will establish that Brian Albert called Brian Higgins first. Brian Albert then disconnected that call when Higgins didn't answer it. Seconds later, Brian Higgins returned the call. Brian Albert then did answer that call. They spoke for 22 full seconds, had a conversation, then they both hung up their respective phones. You'll learn that when they were asked about these calls and conversations, both Brian Albert and Brian Higgins lied about it. Both of them. They said they never had a call with each other. But then ultimately, when they were confronted with their own cell phone records and they could no longer deny the calls, they were asked independently, explain yourself. And they both came up with the exact same explanation: a butt dial. The evidence will make you question, why did Albert and Higgins speak at 2:22 a.m.? And why did they both try to cover up that phone call? You'll also learn after this incident and within days of one another, both Brian Higgins and Brian Albert, both police officers, both trained investigators, got rid of their phones. Both of them. And what else you'll learn Brian Albert got rid of? Shortly after this incident, Brian Albert got rid of his house, the whole thing. Just sold it. His childhood home, a home that had been in the Albert family for generations. He literally sold it mere months after this incident. Dog rehomed, phones destroyed, house sold. You'll learn that all these things happened shortly after the incident where John O'Keefe was found unresponsive and dying in Brian Albert's front lawn. And you'll also learn that Michael Proctor looked the other way. He did not investigate any of what I'm telling you. He pre-selected Karen Reed from the start, and he ignored everything and everyone else. Let's get back to what was happening with the others while Karen slept. What you'll learn during this trial is that Brian Albert's sister-in-law, you've heard her name before, Jennifer McCabe, she was at the waterfall that night, and she was over at the Alberts' house that evening as well. She left the after-hours gathering about 2 a.m., a little before 2 a.m., got home around 2 a.m. And you'll learn that according to the Commonwealth's own evidence from a forensic software program called Physical Analyzer made by Celebrite, it's considered the gold standard for forensic tools. You'll learn that a Google search was discovered on Jennifer McCabe's phone. A Google search that Michael Proctor and his investigators never revealed to us, but we found anyway. A Google search that was time-stamped, according to their own data, at 2:27 a.m. 5 minutes after that 2:22 a.m. call that Higgins and Albert denied having. And that Google search on Jennifer McCabe's phone read, "Hoslong to die in cold." Hoslong to die in cold. Now, she misspelled the first word. Hos is supposed to be how, but the meaning's the same. How long does it take to die in the cold? Time-stamped 2:27. And then that search was also noted by the same Celebrite program as having been deleted. The evidence will force you to ask, why is there a search on her phone? Why is it logged at 2:27 a.m.? When the Commonwealth claims that she first learned of John's death and where his body was hours later at 6 a.m. So what you'll learn is that while Karen slept, here's what was actually happening by some other very busy bees. 1:25 a.m., Brian Higgins makes an unexpected visit to Canton PD. 1:30 a.m., he makes a phone call that he later denies ever making. At 2:22 a.m., Brian Higgins and Brian Albert talk. They both deny and lie about having made that phone call. 2:27 a.m., 5 minutes later, a Google search appears on Jennifer McCabe's phone, Hoslong to die in cold, hours before John's body was ever discovered. A Google search she denies making, and that she later, or at least it was later logged as deleted. Meanwhile, at 2:30 a.m., the plow driver confirms that O'Keefe's body was not on the lawn of Brian Albert's house, not at 2:30 in the morning. And at 3:30 in the morning, that area was obstructed by a Ford Edge like the one the Albert family liked to own. The evidence will show in the meantime, Karen dozed in and out of a fitful sleep for the rest of the night, only to awaken just before 5 a.m. And that's when she realized in a panic, John had never come home. And you'll see, it wasn't like John to not come home. That morning, you'll see and hear evidence that Karen's emotions had morphed. It'd gone from frustration and anger, which you'll hear in the voicemails, to abject fear. Fear that something bad had happened. The evidence will establish by this time, Karen was panic-stricken. She had a feeling something was very, very wrong. She was unable to get a hold of John. Karen went to go look for him. She got in her Lexus and she backed up to leave her garage at One Meadows. You'll hear a lot about that address, One Meadows. That was John's house where Karen was staying. She backed out of the garage, and during the course of the trial, you'll hear that she actually struck another car with that right rear taillight. During the course of this trial, the Commonwealth is going to desperately claim that Karen Reed's taillight was actually damaged by hitting John O'Keefe. They'll have no evidence of it, mind you, none, but they'll make the claim. We'll show you a video of exactly how that taillight was originally damaged, or exactly what happened at 5:07 in the morning. The facts will show that it was damaged in John's own driveway at 5:07 when Karen backed up and made contact with another car in the driveway. This is 5 hours after she dropped John off and he went into the Albert residence. As a result, the taillight was minimally cracked, but it wasn't completely shattered or damaged or broken. And that's the condition of the SUV when Michael Proctor got a hold of it. That becomes important. You'll hear from an independent police officer, an eyewitness to the damage on that SUV, someone not connected to Michael Proctor or under his control. And he'll tell you that he saw the taillight damaged before it was in Michael Proctor's possession, but it was not completely shattered. And you won't have to speculate how that taillight got cracked originally. You'll see it for yourself. It's on video. You'll learn that part of the reason that Karen's Lexus hit that car at One Meadows is because she backed out looking for him at a time when she was absolutely panic-stricken and grief-stricken. Where was John? Why hadn't he come home? What had happened to him? Is he hurt? Is he passed out somewhere? Her mind was reeling. The evidence will establish she wasn't giving anything away. Everything was on the table. What could have happened to John? You'll learn that when she woke up and he still wasn't home, she was just racking her brain for what could have happened to him. And she was worried about possibly the worst. He'd gotten out of the car. He'd walked to the house. She was confused. And later, when she found him at 6 a.m. on the lawn, where she last saw him going toward the house, her mind started reeling. Oh my God, did a plow hit him? Did I hit him? Could I have hit him? What could have happened to him? And that video clip that you saw, out of context, when she said the words, he did not look like he was mortally wounded, she's not talking about at midnight. She's talking about at 6 a.m. when she found him. That's what she was talking about. Your job will be to make sure that the evidence isn't presented to you too cute by half. She was saying all those things. Did a plow hit him? Could I have hit him? Did I hit him? She was saying that to herself and to other people. And the Commonwealth, very obviously, will try to seize on that panic and twist this into some admission. But here's the actual truth. That's not a confession. Could I have hit him? Did I hit him? Could a plow have hit him? That's a person trying to make sense of an unexplainable circumstance, a natural concern of a bereaved significant other, a woman desperately trying to piece together what could have happened on this tragic night. John didn't come home. And the evidence will show that Karen Reed never said, I hit him. Never. Not in the background of the 911 recording, not on any dash cam video, not on any audio, not on any police body cam, not to a first responder. It's never mentioned in a single report. It's never reported in a single report from January 29th, not by one person, because it never happened. The evidence will show that there were at least 13 members of law enforcement or first responders, and 2 civilian witnesses that were intently focused on what was happening at that scene. They were all over the lawn. They were all over Karen. Officer Sarath, Mullaney, Good, Lank, EMT Nuttall, Flamati, Kelly, Walsh, Woodbury, Whitley, Becker, Robery, McLaughlin, Carrie Roberts, Jennifer McCabe. They were all there watching and listening. On January 29th, when John O'Keefe was found, not one first responder reported having heard Karen Reed say the words, "I hit him." Not one. Not one civilian reported having heard Karen Reed say, "I hit him." The facts will show that the first time this improved statement was ever claimed to have been made was some 24 hours later by a single EMT in an interview. Now listen to this, in an interview coordinated by a Canton police detective named Kevin Albert, Brian Albert's brother. And remember, Chris Albert, the other brother, is a board selectman to whom the Canton Police Department reports. And what's more, you'll learn that Katie McLaughlin, that's the EMT, that's the single EMT, the first person to have claimed to have heard this unrecorded and unreported statement, is years-long close personal friends with a young woman named Caitlin Albert. You heard that right. It's Brian Albert's daughter. During the course of this trial, you'll become familiar with and you'll realize that the Alberts are indeed a powerful and indeed an influential family, and that will mean something. You'll learn that there are other major problems with the prosecution's case. The evidence will establish that Michael Proctor himself, the lead investigator and architect of this entire case, has a long-standing and personal relationship with the Albert family. Yes, that same Albert family. His sister was close friends with Julie Albert. He personally sat at head tables at weddings, or at a head table at weddings with the Albert family. He entrusted the Alberts with babysitting his own children. You heard that correctly. And yet he was the lead detective assigned to investigate the circumstances of a Boston police officer laying dead on the Alberts' front lawn. That's not just bias, you'll learn. That's not just coincidence. That, folks, is corruption. And you'll see how far it went. Michael Proctor was alone with all the critical evidence in this case, alone with Karen Reed's phone, alone with John's phone, alone with video footage, alone with the taillight material, alone when he claimed to recover evidence from 34 Fairview. He wrote the search warrants. He transported the evidence. He secured it. He submitted it. He did it all. That's Michael Proctor. And he did it without any reasonable oversight. You'll see during the trial that he intentionally lied and fabricated evidence during the course of this investigation. He lied in reports, warrants, he lied under oath. He lied about the time that he actually secured Karen Reed's vehicle. Why? Why would he lie about that? The evidence will give you the answer. He lied because he did not want it revealed that he had access to that vehicle and he had access to that taillight before any taillight fragments were found at 34 Fairview. Appreciate that. He had access to the vehicle before a single piece of taillight material was ever found at the scene. You'll find that there were 2 searches. The first and second search found 0, nothing. Nothing around John's body, nothing in the street, not one piece of taillight fragment. But once Michael Proctor had that SUV and had the taillight in his custody and control, suddenly items started magically showing up. And not just a few items, 46 pieces of bright red taillight laying in the snow, supposedly found in the exact same spot that was searched not once, but twice by independent officers. It came up with 0. To be clear, you'll learn that before Michael Proctor had access to that taillight, not a single piece was ever recovered at 34 Fairview. That will become vitally, vitally important. And what about those shards of plastic, by the way? What about this DNA that the Commonwealth mentioned. They're going to try to dazzle you with talk of DNA because it sounds so scientific. DNA was on the taillight, but you'll learn that there was no DNA on the actual shards that they claim came in contact with John's arm. None. There was no blood, no tissue, no skin, no DNA on a single shard of plastic that they claim cut deep abrasions into John's arm, the arm that you saw overhead. The DNA that was actually found, the actual science will show it was found outside of the taillight housing where anyone with access to that vehicle would have touched. And it wasn't just one male's DNA. In that exact same sample, there were 3 men found, John and 2 unidentified males. So unless the Commonwealth is going to shift their theory that that SUV hit 3 men that night, their entire theory falls apart. And speaking of DNA, the evidence will further establish that John O'Keefe's shoe, the one that he was wearing when he was found, was sampled. And that DNA revealed 5, count them, 5 unidentified males. Recall that the evidence will establish independently that John was injured someplace warmer and had to be moved onto that lawn. 5 unidentified males touching that shoe. You'll also learn that you are not the first person, not the first to hear about the Commonwealth's theory of this case, that John was hit by an SUV. That's their theory. The Commonwealth presented this exact same claim to their own medical examiner, a woman by the name of Dr. Irini Scorti-Bello. And you'll learn that after reviewing what's called a law enforcement accident notifier, with law enforcement's theory of the collision written in it, defined in it, after conducting the autopsy herself, after examining John's injuries in detail, she refused to conclude that John's death was a homicide based on the Commonwealth's presentation and their theory. That's right. The Commonwealth's own medical examiner will not deem the manner of death in this case, a homicide. She won't do it. But they're nonetheless back again trying to present the exact same theory to you in this trial. Again, the evidence will show that that is reasonable doubt. Throughout this trial, the Commonwealth will try to convince you of paranormal events, phones calling themselves, messages deleting themselves, Google searches made and then unmade, evidence magically appearing and evidence magically disappearing. But all that smoke and all those mirrors will not ever reach their burden. Because that's what this case is ultimately about. It's about the Commonwealth's burden of proof. You'll learn that during the trial, the Commonwealth bears the highest burden known to our justice system. They must prove every element of every charge beyond a reasonable doubt and to a moral certainty. And you'll learn that moral certainty means the highest level of certainty known in human affairs. It's not a small thing. They're not going to be able to do that. Not when every piece of this case was handled by a disgraced investigator with a motive to protect his friends, not when the physical evidence contradicts their very theory, not when their own medical examiner won't call this case a homicide based on the exact theory that they're presenting to you, not when the conduct of those in the House and the utter lack of investigation speaks volumes about those who actually have something to hide. By the end of this trial, you'll conclude that Karen Reed is not guilty of hitting John O'Keefe with her SUV. There was no collision. She's the victim of a botched and biased and corrupted investigation that was never about the truth, folks. It was about preserving loyalty. You'll find that this case is the very definition of reasonable doubt. And at the end of this trial, we'll ask you to return the only verdicts, all 3 of them, that are consistent with the evidence, the science, the truth, and justice. Not guilty, not guilty, not guilty. Thank you.
Thank you, Mr. Jackson. Folks,
All right. Wow. Are you juiced? Are you juiced for this new trial? God. I tell you, I mean, listen, I think you guys have known this. I've known Alan for, I've known him for a long time. I've known him for 20 years, close to 20 years. I've known him since the DA's office. I was his law clerk. I was his law partner as a defense attorney. And I got to say, the guy is a remarkable speaker and an advocate and courtroom practitioner. And I think you saw that on full display here. Listen, I know this is one of those cases that people are heated. People have opinions. People watch the first trial and they have opinions on this whole thing. I watched the first trial, and I am doing my level best to remain objective and view this as a brand new trial, because it is. Because it doesn't matter what we all think about the first trial. It doesn't matter what we all think about what was proven. If it's not proven the second time around, you are not given the ground that you gained the first time around. In other words, everything starts at zero again. We are back in the column of not guilty. And the prosecution, the Commonwealth, has to bring us out of that and prove this case beyond a reasonable doubt. And every witness that was called the first time around doesn't matter. And all the cross-examination that was done by the defense the first time around doesn't matter. And all of the experts that the defense called and all of the arguments that you may found to have been persuasive by the defense the first time around, none of that matters. There was no verdict. Despite the jurors feeling like they came to an agreement, we are back as if that first trial never happened. And that's the same way that the law views it. And that's the way that I'm going to view it. So I will say this. Impressive on both sides. Entirely different styles. Hank Brennan, like I said, never going to light the world on fire. Never going to put you in tears, but the guy knows his case. You cannot deny him that. He knows the facts of his case, and he is going to be a very zealous advocate on behalf of the Commonwealth, and he will do an admirable job. And he knows the theory of his case, and he'll present that, I think, remarkably. Alan Jackson, David Yannetti, Alan Jackson, we just saw here this morning. Abundantly impressive advocate as well. Knows his case, knows the arguments he wants to make, and it has an ability, I think, to spark a certain kind of energy that is not seen all that often. So applause all the way around for everybody, in my view. And I am very juiced to see where this trial will go. As far one other thing that I thought was interesting about the defense opening, and I'm curious to see what you guys thought, is had you watched that on mute? There is a underlying hum of, I feel like, anger coming from Alan. And I hope I'm describing that accurately. And I'm curious if you guys felt the same way. And I think probably the best way of describing it is an underlying indignation. And I'm trying to think about, how do the jurors who know nothing about this case, how are they processing that? He came out hot, right? This was especially juxtaposed to Hank Brennan. Hank Brennan was very measured, very, borderline monotone at points. Alan came out hot. He came out indignant. Now, to a certain extent, if you're the jurors, you might be thinking to yourself, this indignation is coming from a place of, he believes he's sitting next to an absolutely innocent person. And while the words framing may not have come out of his mouth, and third-party culpability was dance about as close to as you can without getting burnt, the there is this idea of what the heck was going on? Who is this Michael Proctor person? Why were there these butt dials? Who are the Alberts? And perhaps they are interpreting that indignation on Alan's part in light of all of this, not evidence, but in light of all of these questions that he's presenting to them that they don't quite know much about. We know who the Alberts are. We know who Michael Proctor are. These are new names to these people. And so perhaps they are saying, oh, that's why he's so upset, because there's so much more for us to learn. And if that is what he did with this, then mission accomplished as far as I'm concerned for the defense. End of the day, I think that the jurors, if you are doing your best to go into this level-headed, objectively, and with a fresh view to this being a new case, I think that you left this morning going, I have no idea what's going on. I have no idea what is up and what is down, because I listened to the prosecution, the Commonwealth, give their opening statement, and it sounds very convincing, and it sounds very thought out, and it's guided by the science and the data, according to the prosecution, and it sounds like something that makes sense. And then I see the statement put up from Karen Reed, and it sounds incredibly damaging. Brennan was much better than Lally in the first trial. This is Mimi D. However, the charisma of AJ is hard to match. That's true. Now, jurors will only give that so much credit, right? Because if you don't have, you can have all the charisma in the world. If you don't have the facts and evidence to back it up, it's not going to get you, it's not going to buy you a ham sandwich. But you're absolutely right. He does have a certain charisma that hops off of the page, as it were. And then I listen to, so that's how I have, that's how I'm feeling after the presentation of the Commonwealth's case. And then I listen to the presentation of the defense case, and I'm thinking to myself, well, now I don't know. Now I do have questions. And we've already seen a lot of this play out. So we know what these witnesses are going to testify to. But when he lays it out the way that he does, you start to think to yourself, well, now wait a second. Why were these people communicating with each other? Why did this investigator get fired? Why did he not seem to pursue things that seemed like obvious leads? Where is this all going? So anyhow, Caitlin, by the way, is that the live feed that I'm looking at there? Okay, we can go ahead. Can I put that up just so everybody can see what we're waiting on? How am I doing this wrong here? Oh, there we go. We're looking at the fan. So we're waiting on we're just waiting on court to get started. So as soon as it gets started, I'll jump off here. But I appreciate all you guys being here. Like I said, this is our maiden voyage. Appreciate you guys being here. This is a place I hope that we can all watch this together, and I hope that we all.
All right, Mr. Brennan, your first witness, please.
Bring the temperature down and enjoy the chat with each other, everybody. Thank you.